the sentence, maintain the conviction.
Item 2.
The accused is acquitted.
Item 3.
The appeal is allowed, and the appellant is acquitted from all the charges. Yes.
Item 4.
So, the appeal is allowed, and the petitioner is acquitted.
Item 5.
The conviction recorded by the trial court is maintained, and by invoking the provisions, earlier provisions, unamended provisions of section 5, the sentence is reduced.
Item 6.
The appeal is allowed, the appellant is acquitted.
Item 7.
Appeal is allowed, the appellant is acquitted.
Item 8.
Appeal is allowed, the appellant is acquitted.
Item 9.
Appeal is allowed.
Item 10.
Conviction is maintained, the benefit of probation of offense is extended.
Item 11.
The conviction is maintained, and probation of offense sex benefit is extended.
Item 12.
The conviction is maintained, probation of offenders act benefit is granted, and however the fine is increased to 10,000 rupees to be paid to the victim as a compensation of the section 257.
Item 13.
The same conviction is maintained, and benefit of probation of offenders.
Item 14.
The fine is increased to 10,000 rupees, and sentence is altered to the sentence already undergone.
15.
₹20,000, the fine is increased to ₹20,000. And insofar as the sentence is concerned, period already undergone.
16.
Sentence of 5 years awarded by the trial court is modified to that of 1 year, and the period of custody already undergone shall be set up.
17,
While maintaining the conviction, the sentence is modified and the Provision of Offenders Act benefit is extended.
18,
While maintaining the conviction, the sentence is modified and the petitioner is extended the benefit of Section 4 of Provision of Offenders Act.
19,
The conviction is maintained and sentence is modified and benefit of Section 4 of Provision of Offenders Act.
20,
The fine amount is increased to 3,000 each, and the same shall be paid to the victim as a compensation under Section 357 CRPC. And insofar as sentence is concerned, benefit of Section 4 is
21,
the benefit of doubt is extended to the petitioner, and the petitioner is acquitted from all the charges based on stands.
22,
The conviction and sentence recorded by the court below is set aside, and the petitioner is acquitted from all the charges.
23,
All the revision petitions are allowed, and the MP notice is set aside.
24,
The complaint case under Section 138 of NI Act against the present petition is not maintainable. Hence, the complaint case is quashed for the petitioners. However, notwithstanding the quashing of the complaint case for the petitioner, the complainant is not precluded to proceed against the present petitioners either by initiating civil or criminal proceeding in accordance with law.
25,
The criminal MA is accordingly disposed of subject to the opposite party paying cost of rupees 20,000.
Lordship, a free copy of the order may be provided.
In this matter, the liberty is granted to the prosecution to initiate appropriate proceedings in accordance with law.
Lordship, a free copy of the order.
Obliged, Lord.
The liberty is granted to
Lordship, a free copy of the order may be provided to me.
Syria has a lot of money, what free? Supreme money. Liberty.
26,
Grateful.
I have dismissed that your petition, by the way.
Yes, Your Lordship.
I have dismissed your petition and I have given you liberty, the authorization to allow you proceed.
Yes,
Your Lordship, Your Lordship, have imposed cost in this matter.
Yes, it will be cost.
That was praying to good to bar association. Mr. Rogard was that then was requesting that cost should we go to bar association because
It's appeared in this matter, so therefore, cost is obvious. Yes.
obliged, Lord.
the criminal MC is allowed, and the impugn order dated 11/3/2022 passed by JMFC in ICC case so and so is set aside.
27,
Allowed the petition and set aside the impugn order. The petitioner is afforded one single opportunity to recall the witness and examine, and liberty is also granted to examine the witness through video conferencing mode.
28,
Same thing. The same thing. Allowed. Yes, same order.
till 32, 7.
In 32, no? Same order.
33,
Criminal MC is allowed.
34,
Petition is allowed, and order dated 17/3/2023 taking cognizance of offence punishable under section 306 IPC in so and so case is certified.
35,
Allowed.
36,
The petition is allowed.
37,
The petition is dismissed with certain observation, and Bar Council of State is also directed to look at proceeding.
38,
The petition is allowed. However, with a cost of rupees 1 lakh to be deposited in the name of the victim. Name of the victim, and the entire proceeding is quashed.
Great. Already been deposited. Soon after the case was this.
1 lakh rupee deposited.
39,
Because see, the problem is the girl is subjected
Yes,
to investigation, and maybe right, may not be right, but 1 lakh rupees.
Great. 39.
39. Petition is dismissed, and liberty is granted to the petitioner to raise all the points before the.
40,
This is. This 40, in view of the judgment in connected matter, these matter has become infructuous and accordingly dismissed. 42, and all the matters,
41, 42, 46.
43, all the matters are disposed of. Yes, thank you. Yes.
Petitioner is a lawyer, and your lawsuit also have the matter only. Yes, and material is there, water logging, probably there is a strike on the road. The petitioner is a lawyer, your lawsuit directed to Learned Counsel to verify. And specify the.
The matter is not listed today.
No.
Give the slip, we'll see, we'll get it listed, we'll see. How can it be done?
Can I make a mention?
By already 212 grams state and cognizance has been taken, the charge sheet has been completed. And the petitioners have taken all the defenses that they should take in the trial. So Being on behalf of the applicant that answer may take up and this.
All these things will come in detail, no problem.
Pardon me. Item 94 of your lordship's list.
Yes,
I'm paying for an adjournment, on behalf of Mr. Lal. He has some personal difficulty,
94. Full matter?
2016,
Yes.
1 week.
What is the problem? See,
Sorry, your lordship. He's gone for his daughter's MBBS admission actually.
okay.
So he's unavailable.
See, last time also you took the adjournment, you know.
Even that time.
7th October you took adjournment. And 26th of June also you have taken adjournment.
26th, I'm not aware of.
You were not ever therefore they defeated me. Right. On the land council for the petition submits that in view of the personal difficulty is not able to attend the court. So therefore he seeks an adjournment in the interest of justice next week of court of law. Next week, so, and it is made clear that no further adjournment in the present case on any ground whatsoever.
Can
I make a mention out of the list?
1 minute, one after.
95.
95, okay.
And joint affidavit to file.
Yes.
The learned counsel needs a copy of complaint which is under annexed. I will stop today. They are actually lawsuits are taking after
2016 matter.
Yes, sir. Only they have to file a joint affidavit. Matter has been compromised. And one compromise has been made before the local entities are under annexed to. He needs a copy of it.
What are the offences?
506 and 294, 323.
We will do it
He tomorrow file the joint affidavit.
tomorrow.
He needs a copy that he will intimate to his client that it is already.
Okay, next week level. Huh? 95, huh?
88.
88.
Notice had gone by special messenger. Case and counter. Compromise.
What do you want?
Notice are restricted.
Notice to the special messenger returned answered. Messenger answered. What do you want?
Through government council. Because this is the act is there. I'm very.
Through IO. Service through IO. Despite the notice issued to opposite party through special messenger has returned answered. Therefore, the notice on opposite party number 2 shall be served through the IO and I don't remember one matter. On the requisite already filed. Yes. It is the requisite already filed. Extra copy give
সেটা আলগা সেটা কোর্টে আমরা স্টেটমেন্ট দেই দিও
अरे why do argue? Give it.
The special messenger report has found that she refused to listen.
Refused to receive. Oh, then say that. Okay. He refused to receive. Okay. I told him, refuse is better for you. For me to do that. Very I told you 1 minute. 101. Yes. 1 minute after 1 minute. 10.
I took 101, my lord. I am for the petitioner, my lord.
You have an opposition.
No, I beg 101 also I have 101 I am submitting. There also what happened this case lordship last occasion party April 23rd before lordship.
I am the personal advocate of Bharati. On behalf of myself, one petition already filed against me, my lord, 80,000 I have taken objection is there.
No, that is not there. No petition at all. There is no petition at all.
সে অলগা খুলে দিলে
The God is your lordship appear from virtual mode from Baripota today, lordship. I pray, lordship, this matter may can be taken up, lordship. At 2 p.m. 2 p.m.
Yes, okay. Hello? Hey, don't convert it to a much like this. Please go systematically. If somebody is mentioning, please don't hold your peace for some. Give respect to the seniors those who are standing. You are the youngster, you should mention it young. All seniors are standing, let them do it. Thereafter you will do it. December. Which one?
50, item 50.
50?
Actually,
What do you want?
just taking argument.
This will go to December, huh? December. Yes.
Item 111, refer the matter to mediation. The entry mediation report is there, the fixed 14 to 11 is fixed. Thereafter,
101.
111 LRC.
11. Everything, everything mediation report at Jan, huh? 2 weeks after.
Right.
2 weeks.
After 14.
14 is there.
Yes.
So after 14 together. After 14.
Item 52 and 53, my lord.
52, 53, yes.
My lord. On behalf of Mr. Das, kindly take to one week after.
So everybody is asking for adjournment. I am adjusting the list. And the people are giving memos. I am not able to accommodate them. The matter is listed in asking for.
Going to celebrate the Diwali.
Everybody want to celebrate Diwali. So, he is helping you out. That's right. I will come in December, but.
Entry model is there, man.
Oh, entry model is there. That is the reason. Okay. What are these matters? See, the entry model business is very dangerous. What is this? What are the entry model here?
No, entry model is not there.
Not there. Okay, then to December. Yes. One, you said 52 and 53.
52 and 53.
Yes.
May I please to mention, my lord?
Yes.
One out of list item.
He is completely restless.
What is the out of list item, lordship?
Yes.
CLMC number 4038 of 2024. Compromise matter, my lord.
Offense?
Under section 307, lordship.
Injury?
IPC. Injury simple in nature, lordship.
Simple in nature.
Yes.
You have filed everything. Injury report, everything you have filed.
Yes, lordship.
If you don't file, I will impose cost. Filed everything. Injury report, charge sheet, and everything filed, then 307.
Not charge sheeted, my lord.
Not charge sheet.
Yes.
Then where from you got the injury report?
Yes.
Then it's with the doctor.
I know from the record of the lower court, lordship.
Get the injury report also. Okay.
Yes. I don't know.
Please.
I don't know item 54 kindly lordship.
Okay. Withdraw. 54 withdraw.
Lordship. Any other number? Vacation store, then Tony withdraw.
The people are very.
On behalf of Mr. Congress.
That's right, but vacation of stay, have you given notice to the other side?
Yes.
You have to give notice to the other side because stay is operating in their favor. I can't fix it like that. You implement them and mention it. Okay. Tomorrow you mention, take it. Take it, intimate, get the endorsement and mention. Okay.
Can I make a mention, my lords? Lords, can I make a mention?
Yes. Your item is 285.
No. I'm making a mention out of the list, my lords.
But you written item number 285. You see?
I'm sorry. My lords, I have filed a 482 application challenging rejection of a 311 petition by learned Sessions Judge Barampur, my lords. The matter is urgent, and why it is urgent is it was posted yesterday for argument, my lords. The fact that this petition has been filed was intimated to the Court of Sessions and an adjournment was sought. Adjournment has been rejected. Arguments have been dispensed with. Matter stands posted for judgment on the 1st. So if the matter is not listed tomorrow, it becomes infructuous.
It is already fixed for 1st of November.
Yes.
First November, because there is no other option. Okay, tomorrow.
Please.
Yep.
Lordships, one last mentioning, your lordships.
Yes.
Lordships, one CRLMC number 3352 of 2022. Here the accused, your lordships, is one lady Benazir Bibi, wife of one person Tito from Kendrapada. Lordship, this matter is pending since 7 December 2022. NBW has been issued, and your lordship, the matter is not listed. There was a specific direction the matter to be listed, and she's not going to the
What
trial.
is this matter? What is this matter? What is he asking for?
Your lordship, the NBW was issued against her. There is a stay of the NBW. She's not going. There is a stay, your lordships, by this honorable court, and she's not going to.
NBW state execution
Yes,
of
your
NBW.
lordships. NBW states she is not cooperating with the trial, and the matter was listed on 7 December 2022. And your lordships had also directed that the matter should be listed on mentioning. Last time I mentioned, your lordships had told the court master to get it listed. And your lordship, since 7th December, it is pending. There is a stay of the NBW, and she's.
But how execution of NBW is stayed what kind of petition he had filed? What was the relief sought there?
Your lordships, I will read the order, your lordships. A prayer is made.
Don't read. What was the petition? Has he challenged the NBW itself?
Yes, your lordships. She had challenged the NBW. It is stayed. And the matter was listed on 7 December, and till now the matter is not getting listed, and she's not going to the trial.
Right, okay. Give the name.
Yes, sir.
Give the name, please. Okay. Yes. Infectious. 57 infectious.
57.
Infectious.
57.
Yes.
Infectious.
44.
This one.
Password.
46.
Mediation was sent to mediation. Mediation report is there. Mediation proceeding. Next date of mediation is 8/11/2024. Okay. Awaiting mediation report. List it, after 18 hours. Okay. Okay.
47.
47 all are for
Notice due to non-filing of the requisites.
ଜାଣିପାରୁନି ନନା ଯୋଉ ଫ୍ରି ହେଇଥିଲା ମୁଁ ଜାଣିପାରୁନି ଦିସ୍ ଦ ଫ୍ୟାକ୍ଟ ଆଉ ତାପରେ ସେ ଆଜି ଆକ୍ଚୁଆଲି ଡାକିବା ପାଇଁ ଆପଣ କହିଥିଲେ ବହୁତ ପାର୍ଟିକୁ ଡାକିବା ପାଇଁ ୱାଇଫ୍ ବାହାର ହଜବେଣ୍ଡ ଆସିଛି କିନ୍ତୁ ୱାଇଫ୍
Requisite why you have not filed? When was the notice was issued? See, requisite you have not filed.
ଦିଟାରେ ହେଇଥିଲା ଆଉ ଦିଟାରେ ହେଇନି
You filed requisite during the course of the day. Due to want of requisite to the notice on opposite party number 2 could not be served by way of last opportunity. Last opportunity, 1 week time is granted to take the necessary steps for serving opposite party number 2. Leave the matter.
ଚାରିଟା ଯାକ
That's the problem. You take interim order saying something.
ଗୋଟେ ଡେଟ୍ ସେ ଡେଟ୍ ଆପ୍ରୋଭ୍ କରେଇଦେବି ଯେମିତି ହେଲେ କଥା
This has become a ploy for getting
Not my husband and wife, my lord.
ହଜବେଣ୍ଡ
All total, my lord, 7 cases, my lord. All cases for 90 days. Other cases,
ଅଲଗା ଗୁଡାକ ସରିଯାଇଛି ଅଲଗା ଗୁଡାକ ସବୁ ହଁ ଅଲଗା ଗୁଡାକ
7 cases.
ଏଇ ଚାରିଟା ସରିନି
so interim order to continue next on Friday, next Friday.
ନୋଟିସ୍ ଟା
You file the document. I'll put it on Friday. Friday? Monday. 11. Interim order is the only problem. Interim order, yes. Yes.
My lords. ଚାରିଟା ମ୍ୟାଟର
notice, first notice ayindi but it.
ନୋଟିସ୍ ହେଇନି
Issue notice, repeat it to file by tomorrow.
ଦିଟାରେ ନୋଟିସ୍ ହେଇଥିଲା
Okay, by tomorrow and list it, along with that's it. 45 hours. Interim.
Pardon, my lords. I may be excused, my lords. I
Here that no further adjournment shall be granted in the present matter, both the matters.
may be pardon, my
Dismiss with cost if you don't come. Yes.
item 44. I may be pardon, my lords. I could not connect when the matter was called. Item 44, my lords.
Sorry.
Passport. Yes. Next.
49. Made picture lordship.
Mr. Sambit Mathur, who is the conducting counsel also, as is badly placed, it might matter be adjourned.
What is this matter?
So rejection of discharge petition also.
It will go to December end. December. How you could on request urgent.
Publish.
Entry what is there?
No.
No.
And 50.
Yes. 50.
51. 51.
Not next week, sir. What is this matter? First tell me. Everybody is seeking adjournment. What to do?
First time, file is not available.
Charge sheet you are seeking to charge.
Rushing of a charge sheet on the basis of a compromise. On the basis of a compromise.
What is the offense?
Offense number 406, 42506, 30 per minor. And ground has taken regarding the compromise minor, but the person compromise.
Nothing is there.
I have filed, madam. I have to file. What is on next week?
Not next week. We go to December. December could end.
Madam?
December. Serially, people are waiting to 53 urgent.
55.
Yes.
May I please, Lordship? Lordship, I'm in virtual mode. Lordship, I pray for a short adjournment.
What is happening today? Everybody is asking for adjournment. Nobody wants to do. What is this matter? Why are you seeking adjournment?
Lordship, I'm unwell.
Okay, then
The petition challenges
the counsel for the petitioner is indisposed. Therefore, she seeks an adjournment in the interest of justice. Yes. December.
56.
blessed.
56 on the family Passover meal.
Passover.
59. 59 will be taken up 2 weeks after.
After my lord, in the meantime, divorce was there, my lord. Divorce has been filed by the petitioner. That may be concluded in the meantime. Let it come 2 weeks after.
There will certainly be dispute.
Say who Chalchita.
Mr. Sahul and counsel for the petition submits that the parties are
Divorce has been filed by the petitioner.
exploring the possibility of settlement, out of court settlement, and hence he seeks an adjournment, leaves the matter. December. December.
And 16.
Receiving case will not. The petitioner filed this application of alleging the order, taking cognizance, not. High order, it is 1/9/2023. It's landed tariffs are taking cognizance on the section.
Yes.
276B and 278B of the income tax assessment, which had only during the corona situation, there was a delay payment of TDS. Therefore, the compensation filed by the department and the London Talco had taken cognizance. Not the issue what yielded before this honorable court is similar issue, same fact. Only DN Holmes case same issue was decided. Fact is same. Only delay 4 days to 138 days.
So the expectation is this is my judgment.
Yes, your lordship. And apart from this, your lordships,
Either.
the circular also, Lord. Circular also, Lord.
There is one more judgment I have passed.
Yes, your lordship's judgments also.
Yes, anyway. Yes.
Well, circular also.
Throw me your reply to Sukas.
Yes, sir. Yes, Lord. Page notified.
Sorry.
Ask
1 minute.
Married? Right, order.
1 minute, sir, 1 minute. 60, item number 60, 61, 60. Okay. Yes. Where are you reading, sir? Where are you reading? Yes.
Reading.
Reading.
Yes, page 25.
25.
My reply, Lord.
Yes.
Reply in compliance to so far issue for initiation of prosecution under section
Come to
B
the
review of the IT Act for the financial 2019-20 relevant financial actions. Sir, by passing an order dated 201.
Where are you said COVID and all?
Reading, Lord. Yes, Lord.
If you give this kind of reply, who will accept?
I have already paid with 18%.
I know, maybe, but what is the delay?
Reasonable due to corona situation.
Period of delay.
Period for due to 138 days.
138 days.
Your Lordship mentioned.
You have not said anywhere corona period and all.
Lord, since I have already paid.
When the petition has been paid, have you said corona?
Yes, I have already paid. Lord.
What I am asking, you are not answering that.
Yes,
where is the petition you said that due to corona you could not?
In my petition, I have taken claim, Lord. In my petition, Lord, I have taken claim, Lord.
Okay.
Due to corona situation.
Where? Which paragraph?
Yes, Lord. Yes.
Which paragraph?
Yes.
Chalo, let us issue notice first and stay the proceeding. Issue notice and stay the proceeding. Issue notice. Yes.
Further proceeding.
Further proceeding stay. Stay for the court. Issue notice.
61.
Petitioner is
also same ID.
61. Directly go. Petitioner is the Land Council for the petition submits that with a delay by about 100 days. 100 days delay?
Delay. Delay 4 to 138 days.
4 to 138 days. He has deposited the TDS amount with the revenue. The delay delay caused in depositing has been well explained under section 178 capital A. Okay, because of the corona, because of the ongoing corona, the petitioner could not deposit the TDS amount. Land Council for the petitioner submits that his case is directly covered by the judgment of this court in DN Homes. And another case, I had given a judgment.
I have not given circular.
I myself had given a judgment.
Yes, Lord,
Watching this. So and so. Issue notice to the open party number so and so. And in the international, the proceeding before the proceeding in CC Cup case number so and so is state. Yes. Next.
62.
62 Miller, not press Miller.
Not press. Okay, not press.
63.
63. Cognizance. Password.
64. 60.
60. Well, sorry, my lord. 63 ta had the list. 63. Okay. 63. What are you asking here? No, I press next to. Not next to. What are you asking me? Whether is I filed the question. Generally, if you don't have merit, you ask for a judgment. Generally. Therefore, I'm just venturing into it. What a good case, my lord. So, what's one might be I don't get similar loan is given. What happened? You required it. If some have taken loan, gold loans from the bank. सुना ही नहीं क्या सुना नहीं रुआ देखो given to the bank properly verified through their appraisers properly verified some proper verification पर they grant loan as a gold you might have gained something else now this one verification for the search the happening in the first appraiser verified
Okay, bank is okay. Second, after that, on which they have also proved that gold is okay. After 3 years, they have said that gold is fake. And thereafter, what happened? The amount we have petition taken, also return, entire amount returns in this case, Milord. And we already paid. Total, you also going to pay 1 million. I'll certify because just like
So many circular, bank circular. What are the diligence the bank officer has to follow when gold mortgage to be taken up? RBI guidelines. Show me that.
how much it is satisfied?
Get that. So because there is a guideline, RBI guideline, when the gold mortgage is to be taken, these are the standard procedure to be followed. And then officers are followed or not, that is to be seen. If it is followed, then after 2 years, whether you have given gold or brass or whatever, easy matter. At the time of giving the mortgage loan, they should have confirmed.
Now that is agreement also, that between the parties, that agreement also annexed in this case, Milord. Agreement is there. According to the agreement, everything is done. Thereafter, they demanded money. Money petition is given. Very good case. Also, just possibly bank.
Bank. Informant is the bank.
Informant is the bank manager is informant, Milord. The bank is the informant.
Include bank also.
Is it to make the party to the bank?
Banks, include bank, let council for the bank to increase the informant is a party to the proceeding. Let him do so during the course of the issue notice to the opposite party number 2. Newly included the opposite party number 2. And Mr. Patra, let council for the state waives notice insofar as the petition number 1 is concerned.
Permission I pro Milord. In this case, I file Milord. They are going to prosecute against the petitioner, Milord.
I would have adjourned it to December. As per your request, what would happen?
Permission I am prayer.
You were asking for adjournment. I am issuing notice. One state. If I would have adjourned as per your request, it would have gone through December. Now I am giving November itself. File the process.
No, file the process. You have a good case, therefore I am saying. No, permission.
No, you include it.
That's not it.
So file the process. At least after 2 weeks. Yes.
64.
And you have a good case, get that guideline.
You everything a document I have filed Milord in this case. Bank agreement. That taken.
Get the RBI guideline.
I am certificate.
Get RBI guideline. There are standard operating procedure. The bank officers have to follow in mortgage, gold mortgage. If they haven't done, they can't fasten the liability on you subsequently after 2 years.
They have also taken step against the
Tomorrow you take back the loan amount. So let us see what bank is.
Now, in the meantime, what happened, Milord? They have also taken action against the appraiser, bank appraiser, who have done this, Milord. Two appraiser, Milord, in this case, Milord.
So therefore, let us go into all this. Yes, next.
64.
Item 64, my lord. Following the cognizance order dated 27/12/2013, offence under section 471, 468, 420, and 34 IPC, my lord.
Yes.
My lord, as per police report, my lord, one the Tapan Kumar Ratha, who is the owner of the three vehicles. He was producing the fake release order. The 4 vehicles were released in her paper, my lord.
Yes.
Can you see the page 29, my lord? Police report.
20?
29.
29. Yes.
Second paragraph.
Yes. From the facts. During the course of investigation. Yes.
During course of investigation.
Entire paragraph.
Yes, madam. During course of the investigation, the post was visited, the spot was visited, complainant as well as other witnesses have been examined and their statement also recorded under section 161 CRPC, and the involved the 4 numbers of trucks bearing number so and so have been seized, and on court order let the said trucks in Jima after the preparation of the proper documentation, verified the ruling.
Yes, I read it. Yes, what do you want to say?
My lord, I am not involved in this case, my lord. One, Tapan Kumar.
That's right. Tapan, you are, come to the next paragraph. Come to the next paragraph. And in that paragraph only 6 other accused persons are involved and you are one of them. We main accused, you are associated with him.
I am not involved in this case.
You are associated. That is the charge sheet. That is the charge sheet. The cognizance is rightly taken. And if you say no material is available on record, and so far as your complicity is concerned, you argue those things at the stage of framing of charges. You may be discharged. You may be discharged. Right on. Yes. Petitioner has challenged the order dated 27/12/2023. 2023 or this is 13.
Your old case, madam.
Now, the order you are challenging, 2013 order you are challenging. 2013. If you have not participated, what to do? Right on. 2013. Passed by learned STJM in VR case number 88/2010, whereby cognizance of offences punishable under section 371, 468, 471, 468, 420/34 has been taken against the petitioner and other accused persons. The counsel for the petitioner submits that recently he has received the NDW in the present case, therefore he has essayed to the cognizance order. He submits that the perusal of the charge sheet indicates that the entire allegation is made against one Tapan Kumar Rotho, and there is nothing against him. I'm not inclined to interfere with the impugn order at this belated stage. However, liberty is granted to the petitioner to raise all the points before the trial court at the appropriate stage. With this liberty, petition is disposed of. Yes, next. Yes, next.
65.
65.
No, legal. This is the petitions are challenging the criminal proceeding initiated in NI Act proceeding. In this case, the accused, you are the accused. I am the accused. The complaint has a plot in Dunduma, that is the OHS, which is Orissa State Housing Board Corporation, and he has get permission from the Housing Board and General Administration to sell the petitioners matter, which is son of the petitioners. Therefore, a tripartite agent has been executed between the son and the son of the accused and the complainant. At the time of execution of the tripartite agreement, 20 lakh consideration amount of 10 lakh was received and 10 lakh was a blank check was received for during the time of execution of the Hon'Ble matter. The execution was scheduled in 15/7/2022. And the check present issued with that mentioned as 25/7/2022. When I am getting the application, I paid the rest amount, but the accused has not returned my check. Yes. Substantially, while initiated proceeding are in the local area, that is Banampur. When he has residing at Bhubaneswar. You have filed a complaint. No, the complaint they are lesser. I am the lessee. I am the mother. My mother is the accused. Yes, sir. Thereafter, so file a complaint before the Banampur GMC for NI proceeding. Such as bounds. Without returning any blank check. From the execution of the salary. Execution salary is 15/7. I am not receiving notice. But the blue was issued. Then the police are informed me subsequently. And I will not as per the order sheet that mentioned that the address is left out from the mention. Show me the complaint. The order sheet was page 17 of that order sheet. 3/2023. The endorsement is address left
without instruction. That is as per the decision of the Supreme Court, my lord, that is the criminal appeal. Court by the way, that is made sufficient. And subsequent to BW issued and the police has intervened me, and then I am acted before the court below. The 17th order dated 3/3/2023.
What is the check amount?
Check amount 10 lakh, 5 lakh, there is no check.
I'll simply issue notice only because of one reason, that 138 notice in the complaint itself, he says that service could not be affected, there is the addressee left.
Yes, ma'am.
Without information.
Yes, ma'am.
So statutory notice is not served according to the complainant himself. So what will be the consequence of this sentence? That is to be looked into.
Yes, ma'am.
That is the limited thing.
Yes, my lord. That is the only thing. As per the criminal proceeding, my lord.
That's the only thing.
That is
the returnable after 2 years. You should notice, yes.
I also no person just timing as well as
138.
there is a chance of settling also.
Therefore, you issue and after 1 week, each after 1 week, you settle the dispute and come.
No, my question is
there is a statutory bar. The statute says that within 6 months it has to be concluded. How can the High Court say it?
Yes, madam. You should notice
this kind of small issues.
Yes, sir. You should notice I am satisfied.
No, you satisfied. You rather you call him. I'll send to the mediation, pay in installment and finish it up.
Yes, yes.
You have taken the money unnecessary. Technically, you are trying to find out. Yes.
66. Earlier.
Yes, sir.
Also listed and order also for 38 first hour, second hour. You are challenging the FPR 307 Indian Penal Code under 2527 Sansat. So far, the FIR is concerned, the present petition allowed to others. Assaulted Maranastra, Jali Honda, Maranastra, Marine, Yabler, Petro, Mundo, and Doctor Judu here. My lord, may kindly see the pairs 14. 14 all are the simple nature ingredient. And both the petition are co-villager. We are trying to.
If it is simple nature, then they may be.
The allegation which they are assaulted by means of Bujani under assault. The injury must be sarcastic.
So police may file a charge sheet after 323 rules. Now, how can he be caught like this? No. Surrender whatever you want. The petitioner has how many weeks, sir? Petitioner has assailed the in this petition is seeking for washing up for the Infosys PS case number 142 of 2024 and the entire proceeding arising therefrom on various grounds. Investigation is still going on.
Yes.
Investigation in the present case is still going on. Therefore, I'm not inclined to.
Seizure is still there.
Not a seat. The state petition. I'm giving that relief. That this petition on instruction from the client submits that you'd why should see if it is 323 they may give 41 notice also. If you take any kind of observation,
307 is there under 25 27.
Investigation is going on. Simple injury, you are showing simple injury. They may file charge sheet under 323 24. How do you know? And they will give notice under 41A. Why are you inviting all these things?
Dispose of this matter with the direction.
What direction I can give?
Only problem was solved for.
What direction I can give?
Direction.
You are watching and you are asking for bail. If I go for bail,
they are trying to settle the matter, and because both are the co-villagers, they are demanding to give up a peace.
Better you settle and tell the police.
Intentionally, police is harassing the petitioner number.
Disposal. and with the liberty to renew the present the appropriate stage, it cause of action still survives. Yes, next.
67.
In this matter, your lordship on last occasion directed me to file a joint affidavit. I have filed, and mediation report also I have given.
What? I have not directed anything.
And I means,
It's first time it is coming.
the second time. Second time. Last time
67. Where is the order? There is no order.
that lordship directed to file the joint affidavit.
This is first time coming.
The second vice versa. I got second time.
No, there is no order.
Because at that time the petition was very drafted in very small para was contained very small para, so that you are not directed to file
The first one.
joint affidavit describing all the facts.
Oh, maybe. Yes.
So that the law, any order did not all the cases are both are present.
67, huh?
Yes. Husband and
This is the 67 is Kamalakant Satpati.
yes, your
Yes.
Comma and opposite party number 2 is. I am asking for the opposite party. That means it's the support.
Also 498A and 307.
Yes, your loss. That is also sir mediation report. Everything was settled. I have already given. Secretary,
Where is that mediation report? No, it's there. I told you these are digital things. Unless you file, see this. I suppose I refer it today. Try to understand. Suppose I refer it today. I'll give it where we'll keep this file. It'll be off the record now. They will throw it somewhere.
that day nursing file.
You don't maintain physical file. That's the problem. So if you, unless you file it in the digital form in the, this will not come on record.
That's right.
You refer past some order and then we give it to them and they throw it somewhere.
You can also be allowed to pass over to
I'll just pass over. I file it so that I can refer it. It may come, it may not come. Don't worry. I'll refer it.
I'll
But you at least you file it.
Yes, I will do. Kindly one pass.
Digitally you file it.
Yes.
And I will refer it. Okay. I will record your statement that you have already filed and I will refer it and pass the order. Okay. After 2 o'clock.
Sir.
Go and immediately file it.
Yes.
Then it come on record. Yes.
68.
Cognizance in view of compromise, my lord. Opposite part note 2 and all of them, they have filed the joint affidavit, my lord.
Yes. What are the offences?
Offenses under section 341, 323, 294, 325, violation 34 Act.
The opposite party under.
Yes, Mr.
They will also file that.
Have you seen you have any problem?
No, sir.
Just check it up. Don't say, do you have any legal issue, anything you want to oppose? Because you are the state, you are prosecuting them. Both of them have agreed, but you being the prosecutor, you are. What are the allegations?
Allegation as per the FIR, my lord. When the one marriage, the Rajesh Malik was going for marriage, my lord, possession, my lord. The petitioner argued them and
That is not with my file for detailed everything.
What verification? He is there appearing.
Yes,
I am but I have not seen my
Is there any legal?
Why he submitted the appeal there? I was searching for where is that
Affidavit is there. Because because the allegations are very minor.
Yes.
I don't. Instance of who is the informant?
Informant Malani is present here.
Malik. Chandramani Malik.
Yes.
And there are 10 accused. Where are they? Where are they?
Also.
Huh?
Let the case be first against all the person.
Where are they?
It's one of them is present. So far as the petitioner part is concerned.
And how do you know if any the other out of 9 somebody is there in the custody, somebody is there somewhere else, somebody is committing crime somewhere? Petitioner 5 is the present, my lord. Why the other people are not there? All the petitioners has to be there, sir. At least they should be present in the court. They have to be present. Otherwise, I'll pass the proceeding the accused who is present. The other people they have to file separate petition.
I would
Everybody has to be there. Without that, there is no excuse. Without that. Okay, when do you want? Tomorrow? Next Monday, man. Monday. Okay. Monday. If they can't come, they can appear through VC also. No problem. Yes.
69.
Yes.
May I please, Lordship? Lordship, in item 69, I am challenging set aside the order that is initiation proceeding the Louisiana PS 42 of 2015. Lordship, in this case,
Which order you want to challenge?
Lordship, FAR. Initiation proceeding 42.
The entire FIR.
Yes, Lordship.
Crossing of it.
In this case, Lordship, charge sheet, I am filed the charge sheet that is page 26, Lordship. In this case, petitioner name has been deleted, Lordship, and I am also taking instruction that magistrate also not taking cognizance against the present petitioner.
Why you file?
Lordship, that extent dispose of this application.
Learned counsel for the petitioner submits that he may in the present petition, petitioner is seeking quashing of for the Louisiana PS case number 42 of 2015 corresponding to GR case number 42 of 2015. After investigation, charge sheet has been filed in the present case on 31/12/2016. The petitioner has not been charged sheeted. Therefore, even he not charged sheeted. The counsel for the petitioner also submits that the trial court has also not taken cognizance against the petitioner. In that view of the matter, the present petition petition is in first case, accordingly disposed of. Yes.
70.
Lordship, also same, Lordship.
70 also same.
Yes, sir. Charge sheet not submitted and not magistrate also not taking cognizance against.
70 also same. Disposed of. Yes.
71.
Oh, please.
Please, my lord. The order of Annexure 6 is on the challenge. It's a private complaint, and where the property of the complainant was given mortgage, kept in good faith and given mortgage to the bank, and it was not returned to the complainant. She filed a complaint in GR case, it was entered in final report. Once she was filed, there she has appeared and admitted she on bail, and she admitted that she has taken the gold ornaments and kept it in the bank. Therefore, an application was filed before the Royal Court below under section 91 CRPC for production of those materials. And the court considered and directed the bank to produce. And in course, and simultaneously also called for objection from the opposite party. Objection was filed by the Lordship may kind of class 2. And step 3 is the order given direction given to the bank.
Yes.
Pursuant to which these documents have been filed by the bank, and thereafter, my lord.
Time is allowed to the last chance to filing objection. In the meantime, call the document relating to the loan account from flow. Document
was filed. And answer 5, your lordship may kindly see this is the show cause filed pursuant to my application by the accused persons. They have admitted in paragraph 5 and 6 of the objection, show cause, that they have taken the gold ornaments and kept it in the bank.
Read it.
Paragraph 5, that the complainant and her husband continued good relationship as a result in the month of May 2020, that complainant and her husband requested to the accused number 1 and her husband for hand loan from the accused number 1 for purchase of a car and took 2,10,000 rupees, only assuring the accused number 1 to pay the same within a very short time in presence of local gentry, but did not return the same in time. Now, paragraph 6, my lord, that after several requests, the accused number 1 and her husband, that Sandhyarani Parida and Ashok Kumar Parida suggested the accused number 1 and they give their ornament for purpose of mortgage before the Muthoot Finance link road, and she also went with the accused number 1 on October 2022 with the other local gentry and assuring to the accused number 1 they will pay the loan amount and interest for the aforesaid mentioned mortgage, and she also has taken all the documents for payment of loan amount.
Yes.
My
There is an admission.
she has admitted. So now what I beg to say that it is in the trial stage. Then she has already entered appearance. And this application was filed for production of papers
Documents from Muthoot Finance.
that was refused on the ground that I have not produced the original document because your lordship may kindly I have given the cognizance order. There specifically reveals that I have filed all the documents relating to the ornaments matter.
The original document would be there with the bank people.
No, bank people, the loan agreement, loan documents are available with the bank. But so far, original documents with regard to purchase of gold loan and the invoices, I have filed it before the court, showing that it belongs to me.
Where is that? Where is that impugn order? Impugn order is that page?
Impugn order is at
Annexure 5.
page 46.
What does it say?
Please may kindly on to page 42. Where of the case record the reveal that this court the complainant has lost an affair. It was bottom portion. It's found that the purchase receipt of the gold ornaments filed by the complainant is Xerox copy without having any signature thereon of the customer as well as its authorized signatory. Also, the documents related to the mortgage filed by the Muthoot Finance Limited before the courts as per court's direction do not specify any description of the gold ornaments mortgaged by the accused person. So also all the documents filed by the complainant are Xerox copy. But my lordship may, I have also filed the copies of the again. I have
let me issue notice. Let us see. Let them go. Issue notice. Huh? Issue notice to the opposite party number 2. Written within 2 weeks. Finally, process will see.
Short returnable.
Short returnable. After 1 week.
On the verge of trial and
no, after 1 week I am doing. After 1 week, yes.
72.
You have the providence, my lord. You have compromise, my lord. We have filed the joint affidavit.
Joint affidavit I have already prepared. But my lord,
here also there are 14 cases, my lord. All of them are there. One is the present, my lord. Letting the another date, my lord. All of them. 11, my lord. Why in your case only 1 or 2 accused are present? They should present. See, these are criminal cases. Yes, you never know where they are. 307 and all. Yes. Have you seen what are the injuries? Because there are 14 accused persons. If all of them have assaulted, it is very dangerous. See, what are the injuries?
Injury copy not in the I locked in the
What is the injuries?
minor injuries are there. But how the dispute is settled? They have also got possibility. That safety is there. That was the reason behind they could not able to.
No, 307 is there.
But 307 is concerned, all the injuries are simple in
Simple index, yes.
And my only prayer is that that subject to loss of acceptance he is the informant. Actually, in fact, is not his handicap, could not able to walk properly. If also dispensed with his presence in the next state.
No, let him come. I would be imposing some cost and he'll get it. Therefore, because he was beaten up by 14 people. And everybody has to bear the blunt of it. I would be imposing cost on all of them while allowing the petition and it will be paid to him. So let him come. Get ready for that and bring that. And tell your clients to come with some money in the pocket. Monday? 11.
The affidavit and Wakafnama and filed in the registry.
And get the injury report. Let me see what kind of injury. Yes.
73.
Not passing on the proceeding.
You are asking password. Affidavit ready. This is for on
Possible proceeding.
On compromise
362 and 366.
Okay. They are married or what? They are
No, they are married. So they have some relationship. The victim fled away with her own permission to the house of the present petitioner. Then after that rescue.
he has not stated anything. So 363 and 366 charge sheet submitted.
Now they settled.
Settled.
They are there.
Yes, ma'am. So I pray.
Check it up.
Okay.
There was law of relationship, whatever. Yes. Password.
24.
Annexure 4 is the order in view.
Yes.
Has been passed in a case under section 138 of the NI Act.
Yes.
An application was filed by the complainant before framing of the charge for directing that 20% to be deposited by the complainant. And your lordship, the jurisdiction comes only after the framing of the charge. But if your lordship will further look into the matter, I have got a latest judgment of the apex court where it has been.
You are the accused.
I'm the accused.
What does it say? 143.
143. A. My lord, my street to come to paragraph 10 of the judgment. I will invite.
Para 10? Here.
Of the judgment. That is at page 8.
Yes.
Towards the bottom, my lord. I am only relying on this, so I am reading. Therefore, clause B of subsection 1 of section 143A will apply only when the case is being tried as a warrant case. In the case of summary or summons trial, the power under subsection 1 of section 143A can be exercised after the plea of the accused is recorded. Now you also may kindly come to paragraph 14. 14. I read out para 10 only to show that the stage had not come.
Yes.
But if your lordship will come to, sorry, that is at page 17.
Yes.
Paragraph 19.
Paragraph
19.
One,
And page 18.
19, huh?
My lord.
Yes, sir.
Here only it has been said that this is not mandatory provision. And the reasons must be indicated.
Provision is directory and
some parameters. Provision is directory. Some parameters for consideration do not exhaustive. Those have been stated here.
That will take and come to the main point.
That is about 1 crore and 20 lakhs has been directed to be paid.
And what is your plea of defense?
My plea is that the transaction has not been analyzed and therefore when it was pending with the government, I am not in a position to repay them back the money. But it was about
admitting that you have.
Yes, Lord. I am not going to. But I am in financial distress, which could have been considered also by the court, taking into the fact that permission from the government is necessary for transfer of the land. I have been handicapped because of want of permission for transfer of the lease. Otherwise, if the transfer is effected, I did not have to pay back the money.
You are not able to give the land as well as the money.
I could have given the land, but it is with the permission of the government.
You refund the money then. That you can't withhold the money and say that there is no permission, therefore
that is true, Lord.
The fact remains that you have taken the money.
I am admitting that I had took money for transferring the land, and the transfer was necessitated because of my other pressing needs where I spent the money. I am now in financial distress.
Financial distress may not be a ground for not invoking 143 capital.
That is what.
That is the idea of the intention of bringing this amendment is only to take care of this kind of situation. The fact remains that you have taken a crores of rupees from someone. And for some reason you are not able to give the land. Then the money you are taking a little bit of that.
What you also say is that
you may have some problem. In the contrary, you see the problem of the complaint.
I would say that what you will also say is absolutely correct. But in
reading one line from here and there, you can't avoid the requirement to.
Here also the parameter, first parameter you also may kindly see. The court will have to primarily evaluate the merits of the case. That is what you will also ask me.
Without by prima facie merit and the other considerations.
And then defense pleaded by the accused And financial distress to the accused can also be a consideration.
That's right, but here the fact is you have taken not only from this man, you might have taken from other people.
No. That's not the issue here.
Are you a builder?
I am a mines owner. I wanted to get rid of this and transfer it in his favor. He paid the money. Government is to grant the permission because that is delayed here. The complaint case has been filed. It may so happen,
But if I'm not wrong, there is a legal bar, section 57 for the Mines Act.
that has been transferred. That has been amended. Now even permission is not necessary.
And then what is the legal hurdle for you?
That is a hurdle.
What legal hurdle?
Permission is not necessary, what I feel, but they had applied and the government is not doing that.
Very harsh case. It's a matter of 20 lakhs only. You pay.
For the time being, you also may protect me for some days.
How much time will you take? I will extend the time. Time for deposit. That I can do.
Like keeping it here, if your lordship grant even.
No, I'll dispose it of saying that you have financial difficulty within certain such time you will pay it. You are a mine owner. You have taken a money from someone to.
This can be settled also in your lordship.
Then I simply issue notice without stay.
Stay for it.
No. 143 in a 138 case, but I would no question of staying.
Lordship may kindly see.
If you want to settle the dispute, I will issue notice next week. Call him. We can sort it out. We can sort it out the entire issue. 138 entire
that is what I was proposing.
So issue notice next week, Friday.
Friday. 2 weeks. Because I will, if I
let him come, I'll see. Thereafter I will extend the time. We will persuade him to, I will let him dispute. I'll simply issue notice, bring him on next Friday, we'll see what can be done. Better is to settle the dispute.
That it's always, that should be there in 138 days, that is the object.
Because ultimately, you have to pay the money.
Somebody who owes money is to pay.
So we will send it to mediation and I'll stay the proceeding, chalk it out on installment basis or something. That is a better idea. Yes. Yes. File the process, please.
Without.
And in this application, the petitioner seeks for passing of criminal proceedings as well as the order dated my letter 28/8/2024 my letter. 28/8/2024 my letter. 34 my letter. The petitioner filed an application for discharge that has been rejected my letter. On the ground that at the time of the filing of complaint petition, the petitioner is not a director. He has already resigned from 1996. This case has been initiated in the year 2002.
Where is the form 32? Show me.
Not annexed 5 minutes.
Annexed?
4 series.
4.
My lord.
Show me. When have you given it to ROC?
My lord.
Where is that?
Page 42. My lord.
Form you file, huh? Form 32, yes. When you have given this form? Date of submission.
Date, my lord.
Date of submission before
1996.
18/3/28. No. Where is that? Where is that?
Page 39. Due to an audible circular, I hereby resign as a director.
Come to 32, form 32. There is a seal.
My lord.
When have you given it?
There is 28/3/1996. Page 40, my lord.
Yes. What is your name? The name is Rajkumar Tudi.
The kinds of glad to pay 38 lakhs.
38, eh?
Second part. On perusal of the case record, it is found that this case was registered on so Mr. Khajana Khojit and so. This case is pending for examination of witness, and as such, this case is at the preliminary stage of hearing. though Lord an advocate for the petitioner submitted that accused has resigned from the concerned company, namely so and so,
96.
neither said resignation letter nor the acceptance of the said letter by the company or any copy of the affected document are filed before this court. Moreover, by the petitioner do not give this court adequate reason for discharging the petitioner.
You will not find, do not have filed, my lord. Now, you will also kindly glance. Another case.
See, but the problem is, even in Form 32, they say that it's a tribal thing, you have to go and establish that. Judgment to that.
Another case, my lord, the Hon'Ble court also back, my lord.
Against the same man.
My lord, same, it's Hon'Ble. So that 10 Equal Remuneration Act, right?
Form 32.
My lord.
What is the prosecution here?
Section 23 and 24 of my lord. Contract Labor Regulation and Abolition Act 1972.
Contract labor.
22, 23. Punishment is 3 months.
Have you seen it?
No.
Check it. Issue notice and next week, next week, notice. Just check. And file a reply because he's apparently. Scattered, which is the amount of the DA, is rupees 5,45,997.
Yes.
And I will request your lordship to kindly come to page 37 of the running page 37 of the brief. Yes. Yes. The running page 37 of the brief, which portrays the assets, the movable properties under the heading movable properties, lordship may kindly see. Yes. The cash recovered is 3,24,094. Lordship, 3 lakhs under the movable properties, item number 2nd, cash. Cost of running 37, lordship. Cash, lordship. 3,24,000. Cash, 3,24,094. Right. Then starts from the fifth one, SB account number 2 to the last item at page 39. Page 38 and 39. All are accounts. All are accounts and deposits. Yes. The deposits amount to rupees, lordship, 9,12,646.46. Yes. And out of the cash that was seized, the vigilance department had released an amount of rupees 1,50,000, the treatment of my wife, which out of the 3,24,000. Yes. 1,74,094 is retained by the vigilance. Yes. So the vigilance department is in possession of properties amounting to more than 10,86,740. Yes. And the DA amount is 5,45,997. And what has happened, lordship, my dwelling house is again being confiscated. There is absolutely no need to confiscate my dwelling house. Yes. Yes, sir.
There is no basis on that submission, my lordship, so far as the confiscation case is concerned, as per the statute. My lordship, only always, my lordship, is the present market value of the property. And the confiscation is subject to, it is a consequential to special court trial case. Initially in the affair, there was a DA of 16 lakhs. And in trial, it has come down to 5 lakhs some odd.
Yes.
So 5 lakhs some odd is the DA amount which is to be confiscated finally. Whatever that may be the in confiscation case, but it is consequential to the trial's determination. So my
The trial what says?
105.
105.
Yes, no.
Yes.
105 page going later.
105.
105
Okay.
of the judgment.
Yes.
My lordship, the paragraph starts in view of the above conclusion.
In view of the
In view of the above conclusion arrived by the Learned Special Judge Special Court, Bhubaneswar, this court has to hold that cost of above two buildings, so and so, where rupees 2 lakhs and 2,50,000 respective, which are as per the disproportionate asset, and thereafter, hence the cost of the total immovable properties of opposite parties which are to be confiscated. My lordship, it has come down to 5,45,987, the last line.
No, yes.
And but the immovable properties amounting to 4,84,300 and other properties amounting to rupees 61,000 are to be confiscated. My lordship, thereafter, in paragraph 9 may kindly see. Let us have a glance on section 15(3) of Orissa Special Court Act 2006 before we proceed further. Section 15(3) of Orissa Special Courts Act 2006 runs as follows. Where the authorized officer records a finding under this section to the effect that any money or property or both have been acquired by means of the offence, he shall declare that such money or property or both shall, subject to provision of this act, stand confiscated to the state government free from all encumbrances. Thereafter, it is important, provided that if the market price of the property confiscated is deposited with the authorized officer, the property shall not be confiscated. Market value of the property.
The market value we can deposit that.
Yes.
That option. Yes.
And it has been determined. Market value has been determined in this order. My lordship, kindly turn to page 109.
109.
Yes, madam.
Yes.
109, order in person. My lordship, got it?
The
petition filed by state applicant of this Orissa so the properties described in schedule A and B appended to this order are held to be acquired by opposite party number 1 between B and Ponda by committing an offence under section so and so of 90 and disproportionate to his known source of income during the check period from it. Such properties are valued at 2 crores 18 lakhs 92,579. So he has to deposit. So this is the present market value.
Just. Lordship, this submission is not totally correct. And because Lordship, the purpose of the act is that the state government is to confiscate the properties amounting to the DA. It does not mean that the court will pick and choose from properties and hold that this is disproportionate. It cannot, court cannot.
What was the check period?
The check period is from
82 to 97.
Yes, Lord.
If suppose 97, disproportionate asset is 5 lakhs. You check.
Yes,
Lord. You check. It is to be confiscated today.
Yes.
Today's market value has to be seen. Not that 97.
Very simple matter.
Exactly. That is what is also my submission. My submission is that as on the day when the case, my house was searched, they have retained properties more than the DA. That is my submission.
That time the DA was 16. Ultimately it has come now. In retro you can't see that.
It is 5 lakh.
In retro, but on that day when the confiscation is taken place, it was 16 lakh.
No, confiscation on the date when confiscation has been ordered.
That time it 5 lakhs was not there. Subsequently it has come. Subsequently it has come that to 5 lakhs.
Lordship, trial was on the basis that I was in possession of DA to the tune of rupees 16 lakhs and odd.
That is the charge sheet.
That is the charge sheet.
Right.
I was tried.
Confiscation had taken place.
I was tried, Lordship.
Right.
I was tried and the learned trial court held that the value is 5,45,000.
Right.
Lordship got my point.
The day when the confiscation had taken place, taking 16 lakhs, that was correct?
No, confiscation did not take place.
When the confiscation?
Confiscation has taken place against this order which I have come. This is the order of
when?
This order, date is, I am pointing out, Lordship.
Date. Give me date line.
Date is 39/2024.
30.
30/09/2024 is the date of confiscation,
Yes.
which is based on the judgment of the trial court.
Okay. That time it was 5 lakhs.
Lordship.
That time it was 5 lakhs.
At that time it is 5 lakhs. And my submission is that, Lordship, properties amounting to more than 10 lakh has been retained by the vigilance from the date of the outset. So if the market value will go up, then I'm not concerned, because on that day itself, they have retained properties worth more than 10 lakh.
Show me any judgment to that, if you have any.
Judgment, that option is not there. Let's see if we can take instruction on that property. That you can take an instruction, how much property they have retained.
And we have not retained, it is has been seized and it has not been.
And they are the provider. They say that the value of the property you deposit and finish it up. That's what they say. Value determined. If you are contradicting the value, then tell me.
Lordship, my submission is that, again, Lordship may kindly come to page 16. Section 16 of the Act.
Yes.
Section 16 of the Act, Lordship may kindly see. That, may I? So it's a Special Courts Act.
Special Courts Act.
Section 16, Lordship.
Special Court Act है इसमें. इसमें.
Where after the issue of a notice under section 14, any money or property or both referred to the said notice are transferred by any mode whatsoever.
1 minute, sir. Not getting. Especially more. Where is the? Get some. Sorry, I'm direct. Or put the flag here. Put the flag. Yes.
Section 16, Lord.
1 minute. 1 minute, sir. 1 minute, sir. 32. No. It's something different. You have to take it different. Yes, sir.
Sorry, I
Yes.
submitting, sir.
Transfer.
Where section 16, transfer to be null and void. Where after the issue of a notice under section 14, any money or property or both referred to in the said notice are transferred by any mode whatsoever, such a transfer shall, for the purposes of the proceedings under this act, be void, and if such money or property or both are subsequently confiscated to the state government under section 15, then the transfer of such money or property or both shall be deemed to be null and void. So I cannot transfer.
Yes.
Nobody can transfer the land.
It has nothing.
Nobody can transfer the property.
Now, see, the object of act is, suppose in the check period, you have illegally acquired some property.
Lordship.
Okay.
Lordship.
That property has to be
Confiscated. Yes. Yes.
And once it is confiscated,
Lordship.
and equivalent to the price of that property, you can pay it back and then money will be, the property will be released. That's the whole idea of the idea of that.
Yes.
What I understood from your submission is, if the 5 lakhs is disproportionate asset,
5 lakh
to the extent of 5 lakhs, you can attach a property, and market value of that property you determine and pay, no problem. That's what you are saying. But what happened in this case, according to you, is instead of the confiscation to the extent of 5 lakhs, and the property worth 10 lakh was confiscated.
No.
On that basis, now the property is calculated.
No, Lordship, that is not my submission. I am misconstrued. My submission is that, Lordship, on the date of house search, the vigilance department took from my possession 3,24,000 and odd amount of cash.
Yes.
Lordship got it? And my accounts were pinched. My account standing in the bank.
About 10 lakh.
About 9 lakh and odd.
Yes.
About 9 lakh and odd. And out of the seized case, the vigilance, later on, I applied to the vigilance department, 1 lakh something, 1 lakh 50 they have released.
Right.
1,74,000 is being returned with the vigilance. The vigilance has kept that amount. And the deposits are freezed at their instance. I have not dealt with the properties.
What you say is after 9 lakh something.
Yes, they will
that is suffice for the purpose of the the property need not be attached.
It's not the purpose of the act, my lords.
Now you see what he says that 5 lakhs is disproportionate.
Yes.
In cash amount you have already confiscated that part. So why are you confiscating the immovable property? That's what he says.
5 lakhs, my lordship, out of the property of the charge sheet, that is 16 lakhs. At that point of time in 80s, my lords. And the present market, and he has enjoyed that property, house building and other things till the death, my lords. So far as this act is concerned, it is confiscation is subject to determination of DA by the trial court. Now trial court has decided
5 lakhs.
No, it is not 16 lakhs, it is 5 lakhs.
So you say that 5 lakhs cash you have already kept.
And
you say even 5 lakhs, be happy with that. That's what it says.
Section 15 says that if he will deposit the present market value of the property, and it's
he says that of the property. He says that 5 lakh, the cash which you have taken, that is suffice for the purpose of 1 minute.
And my lordship, 105 plus my lordship,
yes.
And thereafter it has been discussed in detail. My lordship, after that.
You can't have both the property as well as cash.
Yes. No, my lordship, what has happened, my lordship?
To satisfy 5 lakhs, you can't have both the property as well as the cash.
My lordship, so far as the determination of the DA by the trial court, he has categorized which properties are to be declared to be DA. And 106, that section I have read out. That section provided that if the market price of the property confiscated is disposed of deposited with the authorized officer, the property shall not be confiscated. Thereafter, my lordship, it has been vividly discussed herein. In view of the section 15.3 of the Orissa.
You seek instruction whether the cash amount which you have already freeze and taken, will that suffice for the purpose of
confiscation or not?
If it
President, market value of the property.
Determined is no property. You want the property. Then what he says is you leave the property and pay the money.
No, that's what 1 minute. 1 minute.
As a market value. Do you have a right to choose which one you will take?
No. Then it has been.
And like to show me where you have a right to choose.
It has been specifically stated in the order portion. Which properties?
That is what he is telling me.
No,
the order is wrong.
Now they are challenging. They are challenging that 5 lakhs determined by the I was during 82 at the time of houses. That cannot be. That has been appreciated highly.
Which means the immovable property only wants to recover that. The property which you have attached, and that is acquired by him through the money. Link that to the property.
Simply, I will show your lordships the judgment of the Honorable Supreme Court in regard to the present market value of the property to be.
Okay.
I will
just issue kindly judgment that you.
But it needs to be considered.
Okay.
I will show.
Lordship, tomorrow is the last date given in the order for vacating the house. So in the interim, the order is stayed.
You can't vacate the house.
Till the next day.
Are you staying there?
Yes, I am staying there.
Oh, MP not stay till next date of it. Vacate. Already you have more than 5 lakhs with you. More than 5 lakhs with you is there. Only whether the property to be attached or not, that will be decided. I'll decide it.
May I make an
Authorized officer has determined it is the present value is 2 crore.
But the problem is it has to be stayed because they are staying there. You can't throw them out.
They are staying in the complicated property.
No. This why don't you get gracious enough to refund all the money? 1,50,000 rupees you refunded. The other money you have kept it with you. Reverse, just see the reverse. If you would have not engaged those property, cash, they would be like in somewhere else and getting money.
And actually, they are
We also have reverse thing.
those are the ill-gotten properties also.
That is why you show me the finding.
Yes, madam.
Whether from the ill-gotten money, this property was acquired or not. If that finding is there, you can link it and I can understand.
May I make an humble request? Lordship may kindly mention in the order directing him to take instruction as to the extent of property retained by them.
I'll not hold his hand, let him come and argue whatever. I'm just issuing notice and saying the impugn order till next day. Yes. Yes.
77. Please.
NBW.
NBW was issued on 30/9/2024.
30/9.
Again.
And you were on bail?
Bail on 5/7/2022.
5/7/22, yeah. NBW, where is that? NBW? Yeah, okay. 500, yes.
78. Hon'Ble.
Yes.
Please. This is a Belgium matter.
Yes, you can be.
My lord, NBW was issued on 9th of July 2024 and the petition was granted bail by the Supreme Court in BLAPL 5042 of 2020. 12th of May 23.
12th May, huh? So 20th of the 20th of 25th of the 25th of November. Okay. Yes. Hello. 500, yes.
79. May I please your lordship? My lord, NBW order 23/2024.
Yes, Mr. Roland, this Belgium. When the NBW order was passed?
23/2024.
23/2024. 500. Okay. Hello.
80.
May I please, Lord? Petition in custody since 23/9/2023. He was taken on remand. In fact, he was in custody in connection with another case. In this case, he was taken on remand.
Custody since
23/9/2023. 12/9/2023.
12/9/2023.
Yes.
Okay. Yes.
Taken on remand in this case. Prior to that, he was arrested
in custody in some other case.
In another case.
Confiscation. Confessional statement.
No, not a confessional statement. Who are each persons against whom
They are in custody.
who are the main accused persons that my learned friend also pointed out.
What is the role it will get?
What happened, my lord? The deceased having 3 wives, my lord. 3 wives. This petitioner, my lord, there are love relationship between the petitioner and one of the daughter of the deceased, my lord. And for which the deceased asked her daughter not to contact the petitioner, my lord. For that, thereafter, the daughter of the deceased became ill and taken to hospital and expired. Since then, the petitioner wanted to kill the deceased, my lord.
Okay.
That is the case, my lord. While the petitioner in jail custody, that is a confession statement. While the petitioner in jail custody, my lord, the other the principal, 3 principal, they are also in the custody, my lord. There is a conspiracy between them, 120B for that is 120B there, my lord. After they released from custody, they contacted each other, my lord, and brought out a sword and accordingly assaulted the deceased, my lord. By the time the petitioner in the custody, my lord.
Achha.
And
because of 120B,
since there is a reverse enmity, for that reason the petitioner.
he was in custody in
Another case.
302. For what is it?
In the case he is acquitted.
Other
In the
cases.
case he is acquitted.
In the case?
Yes.
Other cases, my lord, for that they have but all total against the petitioner, my lord, 9 cases, my lord.
9.
Why will you come out?
My lord, here all the cases
To commit inside the jail, you started conspiring
And so far
120B.
so far the antecedent part is concerned in respect of Kaliasa was also against him, no numbers of antecedents were there, your lordship granted bail. And so far the principal accused persons is concerned, your lordship had already observed on the basis of my learned friend's submission that who are the main accused. So far,
crime there.
court double is 9.
They are not applied for other three court, they have been
Court double is
Any file affidavit, how many cases?
Yes, that is there on record.
What are they then direct, there is no direct evidence.
120 be there. I read out one statement only, there should be.
Yes.
Apart from the confessional statement of the coerced persons, my lord, one statement, my lord.
Yes.
तुलसी चौधरी ମୋ ନାମ ତୁଳସୀ ଚୌଧୁରୀ 14 ବର୍ଷ ମୁଁ ନବମ ଶ୍ରେଣୀ ପାଠ ପଢୁଛି ମୋର ମା ଆଜି 2 ବର୍ଷ ହେଲା ମରିଯାଇଛି ମୋ ବାପା ସାନ ମା ସୁମିତ୍ରା ଚୌଧୁରୀ ସହ ନୂଆ
457,380 and the similar circumstance Sheikh Sairaddin, he has been granted bail. Also same number of cases.
Same affair.
Same affair, my lord. Arranging the same case, my lord.
Yes.
Case number 113, PS case number 227 of 2024. This is relating to the, I have annexed the FIR and both 380. Traveler, then a magistrate first class, my lord.
Yes.
Petitioner who having custody, my lord, remanded this case, my lord.
My lord.
More than 16 cases, my lord. 16 cases. Cases 37 petition 3, my lord. All the temple, my lord.
Problem is wherever there is a theft in the temple, you couldn't find anyone. Whoever comes, record confusion and this is what is happening. 16 cases.
16 cases.
And you rely upon only confessional statement.
Actually, what happens is you
are not able to solve the ornament and you cut off one and
he knowingly committed all the ornaments of the things, my lord. All the cases similar cases.
Allegations are serious, but the fact is the quality of evidence. Allegations are very serious. What quality of evidence you have?
That is
Any recovery?
No recovery from the person. Similar to like my lord Sheikh Sairaddin, your lordship granted bail. Sairaddin.
You tell me, so far as this accused is concerned, have you recovered anything?
On the basis of the statement of the accused by the of 27 evidence, some of the stolen property have
What is that? Some of. Vaguely you can't say some of.
Some of. That's the case, my lord.
Some of means what? A spoon.
My lord.
What is that? You have to tell me what are the things you have recovered.
Sheikh Sairaddin.
Nothing is there.
Some utensils, my lord, utensils, border konsa thali, घंटी पूजा सामग्री, all these things, my lord.
Very weak evidence.
Of the teach.
Petition is accused and so on. Okay. Negation against the petition is shown. It is, you were in custody in which case?
Same bed. 17
confidence.
That is remanded in Chandipur PS case number 46 of 2024.
When the petitioner is accused, petitioner is accused in age when he was 16 case. In PS Chandipur case number
46 of 2024.
24, he was taken into custody. While in custody, it is alleged that he has confessed to have been involved in other cases, including the present one. On the basis of the confession statement, the petitioner has been taken into custody in the present case.
Except the evidence actually there.
Except to the confessional statement, there is no other evidence is coming to the fore. In the present coming to the fore. However, Mr. Raghuram calls for the submits that the confessional statement of the present accused led to recovery of the stolen articles. I perused the record and found that no specific there is although recovery is told to have been effected from the petitioner, but particulars of recovery articles has not been mentioned. Mr. Das, learned counsel for the petitioner, has relied upon the order dated 19/9/2024 passed in BLAPL number 5707 of 2024. SK Sahiruddin versus State, wherein in the whereby the co-accused has already been granted bail. Apart from that, the other co-accused have also been enlarged on bail in the present case. Regarding that,
Since it's secrecy manner, he has to appear before the police.
What's condition of
before the police would take 6 months. 6 months.
Public.
6 months, yes.
82, may I please?
You are in custody since?
Same day, same day.
Date.
15/7.
The copy. Where is that? Where is that order? You give that order to us. Item numbers are put together.
17/5/2002. Yes. Obliging.
82 minor inside custody from 24/6/23 minors.
24?
24/6/23 minors.
Yes.
Earlier, minor they disposed of by saying that they after framing of charge and the examination of the eyewitness, maybe after that it will make that is the order.
Eyewitness has been examined?
Yes, examined and material.
Show me that order.
That minor order. And they have annexed the eyewitness statement minors, page 14 minors. The para 5 minor.
Eyewitness, namely
para
Bhagwati Kishan.
Yes, madam. So that is Bhagwati Kishan. I have annexed it in page 14. May I kindly read, my lord?
Yes.
I know the informant of this.
No, where have you flagged me?
Yes, 14. Page 14, annexure 3, my lords.
Annexure 3, okay.
Yes.
Okay.
I know the informant of this case. I know the decision of this case with my co-villager. I know the accused of this case standing in the dock.
No side.
Yes, my lord. So all the material. Yes. And all the material also all are hostile.
Yes, sir.
All total, my lord, 13 witnesses examined, 13 witnesses in the meantime.
Nobody is supported. Nobody is supported.
Bhagwati Bhag, my lord, declared hostile. And what happened in this case, my lord? Actually, the petitioner is the son of the deceased, my lord. He committed murder of his mother, my lord. Demanded money and thrown a stone.
No, my lord.
Stone on the head of the mother.
But it's all right. But allegations are serious. But what to do? You are not able to get an evidence.
My lord. Even if his daughter, my lord, own daughter, he has not supported the case of the deceased.
This is also case. Is in custody since?
But also, my lord, the brother-in-law of the deceased, my lord, he has not supported.
24/6/23.
24/6/2023. Earlier, this is the second round. Second round of the prayer of bail made by the petitioner. Earlier, this court, by order dated 28/8/24, in BLAB number 13939 of 2023, although rejected the bail plea of the petitioner, however, liberty was extended to the petitioner for renewing the bail plea after the examination of the eyewitness, namely Bhagwati Kishan and other material witnesses. Mr. Ravana and Counsel for the State submits that out of how many witnesses?
All total, just 31 witnesses.
31 witnesses, 13 witnesses have been examined. The 13 witnesses.
13 examined.
13 examined. Next paragraph. 13 witnesses, including the eyewitness.
This is under the informant.
Bhagwati Kishan, who was examined as PW1. The other material witnesses. PW3. Other material witnesses have also been examined. Neither the eyewitness, Bhagwati Kishan, nor who is not supported, you said?
The informant, my lord, himself.
Nor the informant.
And also the daughter.
Informant and the daughter of the deceased.
The daughter, my lord?
Material witnesses. Material witnesses has not supported the prosecution. Therefore, they have been declared hostile. The petitioner is in custody since 24/6/2023. 2023. सब regarding head to it to fact नहीं allegation of the petitioner. Allegation of the petitioner. First I think the FIR, तब allegation of the petitioner. Correct. Yes, sir.
83.
Wait, please.
This is a CR. The CLMC was listed before this Honorable Court on 1/5/2023, and the advocate concerned actually he missed the list and could not appear when the matter was called up.
What is that order?
Order was on 1/5/2023.
1/5/2023.
And we immediately filed the petition.
Where have you filed that order?
My lord, in the petition, I have mentioned, I have quoted order.
Very interestingly, you have not filed a single document as an annexure. Except the petition, there is nothing.
Quoted in paragraph 2.
Everything, annexure also you quoted these things saying with that order you should have filed, man. Where is that order? Let us see.
Paragraph 2.
I'll restore it. Restore it. But what is there in merits?
There is merits. I'll
tell me on merits, I'll restore it. Tell me on merits. Whether you really have, see, if you really have a good case on merit, I'll restore it.
Yes, my lord, I have a good case because this is only relating to coal theft, and I am a senior security officer who has nothing to do.
Where from I'll get all these things? You have not.
That CRMC is also there, na petition.
Oh, that petition.
Yes, my lord. And he is the senior security officer.
Okay.
And
CRLMA, for the reasons stated in the CRLMA, the same is allowed. The CRLMC 1275 of 2021. What is that? 2020?
Yes, my lord.
Is restored to its file. Leaves the matter for dispute.
My lord, I have another prayer. There was an interim order which got
restored to its file means everything is restored.
Yes.
Everything is restored. Yes.
Grateful, my lord.
But it is made clear that on the next date of hearing, the matter will be heard finally, and no adjournment shall be granted. You be ready with that.
Yes, my lord. Grateful, my lord.
84.
You may know the date.
Date he give next date of November last.
Yes.
Yes.
84.
Yes, sir. In person you are appearing.
My lord.
Okay.
My lord, order dated 11/10/2022.
11/10/2022
ପୃଷ୍ଠା 2 ଦ୍ୱିତୀୟ ପାରାରେ ଲେଖା ହେଇଛି 30/4/1999 ପରେ ମୁଁ ଚାକିରିରେ ନଥିଲି ମ୍ୟାଡମ।
11/10 let me get that order first. 11/10
ମୁଁ ଓଡ଼ିଶା ଷ୍ଟାଫ ସିଲେକ୍ସନ କମିଶନର ଏକମାତ୍ର ଟାଇପିଷ୍ଟ। ମ୍ୟାଡମ ମୁଁ 34 days minimum scale of pay.
Is it marked to me?
Yes.
Matter is marked to me.
Review.
Okay. Yes, sir.
My lord, 30/4/1999 ପରେ ମୁଁ ଚାକିରି ନଥିଲି, ସେଥିପାଇଁ ମୋ ଚାକିରି ରେଗୁଲାର ହେଇପାରିବ ନାହିଁ ବୋଲି ଲେଖା ହେଇଗଲା। My lord, ମୁଁ ଏକମାତ୍ର ଓଡ଼ିଶା ଷ୍ଟାଫ ସିଲେକ୍ସନ କମିଶନର ଗୋଟିଏ ମାତ୍ର ଟାଇପିଷ୍ଟ। ଏଇ ଅର୍ଡର ପାଇଲା ପରେ ମୋର ଅଫିସ ଚେୟାରମ୍ୟାନ ମୋର କାମକୁ ଷ୍ଟେନୋକୁ ଦେଇଦେଇକି ମତେ ପେଣ୍ଡିଂ ଫାଇନାଲାଇଜେସନ WPC OAC 30/46/1999 କରିକି ମତେ ଡିସଏନଗେଜ କରିଦେଲେ।
ଆପଣ ये जो ऑर्डर 11/10/2022 ର ଅର୍ଡର ରେ କୋଉ ପର୍ସନ ଆପଣଙ୍କୁ ରିଭ୍ୟୁ ଦରକାର? କାହିଁକି?
They have challenged it in the read petition, my lord. Read appeal. They are the withdraw that read appeal, my lord. They are after 526 days after they have filed this case, my lord. And they have to delay of application may be taken personally.
My lord,
limitation. 526 days, my lord, delay for filing this petition.
My lord,
ଆପଣ delay ଟାକୁ କେମିତି explain କରିବେ?
order 5/24, my lord.
My lord, 2024 ରେ ରିଟ୍ ଆପିଲ ଯାଇଥିଲି। ଅନରେବଲ ଚିଫ ଜଷ୍ଟିସ କହିଲେ ଏଇଟା
ଯଦି ମେରିଟ କିଛି କରି ହଉନି। ଆରେ Okay. In the March 2024, he has withdrawn the writ appeal to file the review, and it was allowed. It was allowed. That's what he says. So then, section 14 covers him.
Can taken the Malad, can't look into the order written on 5/9/2024, Malad. The coordinates means Malad pass an order.
5/9/24.
ମୋର ଦି ଜଣ chairman
1 minute.
Yes.
ଟିକେ ରୁହନ୍ତୁ ଆମେ ରାସ୍ତା କାଢୁଛୁ ଆପଣ ଯଦି କିଛି ହେଲ୍ପ କରିହେବ ଇଜ୍ ନଟ୍ ଆର୍ଗୁଇଂ ଏଗେନ୍ଷ୍ଟ ୟୁ would also try to help you out, don't wait. Yes. Request take us out who are to appear in person. Yes. What do you want?
They are one of the.
See, he is covered by section 14 because forget about the limitation part. Let us come to the merit. What he is trying to tell, just understand. କୁହନ୍ତୁ ଆପଣ କଣ
କହିବେ? ଦି ଜଣ ଚେୟାରମ୍ୟାନ ମତେ ରେଗୁଲାର କରିବା ପାଇଁ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଇଏ ଡିପାର୍ଟମେଣ୍ଟକୁ ଦେଇଛନ୍ତି, ଯିଏକି ରେସପଣ୍ଡ ନମ୍ବର 1 ମାଇଲର ମତେ ଯୋଉଟା କି ମୁଁ ଜଣେ ଚେୟାରମ୍ୟାନ 2012 କୋର୍ଟକୁ ମଧ୍ୟ ଆଫିଡେଭିଟ ଆକାରରେ ଦେଇଛନ୍ତି। ତାହା ଆନେକ୍ସ 6 ପେଜ ନମ୍ବର 16 ଇନ୍ WPC ନମ୍ବର 1561 2012 ର ଶୋ କଜ ରିପ୍ଲାଏ ମାଇଲର ଦେଇଛନ୍ତି ମତେ ରେଗୁଲାର କରିବା ପାଇଁ।
Yes.
ମାଇଲର ମୁଁ ଖାଇବାକୁ ପାଉନି ବର୍ତ୍ତମାନ 26 ବର୍ଷ ଚାକିରି ଗଲା ପରେ ମାଇଲର ମତେ କୋଉଠି ଚାକିରି ମିଳୁନି, ମୁଁ କୋଉଠି କାମ କରିପାରୁନି ମାଇଲର ମୁଁ ପିଲା ଛୁଆ ଉପାସ।
Page 12, my lord. The order, my lord. 11/10/2022.
WPC 1097/2002 ମାଇଲର ମତେ ଟ୍ରେଜେରୀ ଅବଜେକ୍ସନ କଲେ ମୋ ବିଲ୍ କୁ, ଅଫିସ କଲେ ତମେ କୋର୍ଟ କୁ ଯାଅ, ମାଇଲର କୋର୍ଟ କୁ ଆସିଲା ପରେ ମତେ ରିଭାଇଜ ସ୍କେଲ ଅଫ୍ ଫେରେ ମତେ କୋର୍ଟ କୁ ଆଦେଶ କମେ ମତେ ମିଳିଥିଲା।
Problem is not in continuous employment.
For that, it was 11/10/2022. Where one this only court coordinates my lord dispose of the.
So that's right. He was employed in a spell basis for small period. In continuity, he doesn't have the continuous service of 200.
The court, my lord, the coordinate held that on 13/4/1999, the tribunal extended the interim order until further order. By the time such order was passed, the petition was no more in service.
That's right.
There.
I've seen.
That is my lord.
What way he can be held? Because but fact remains he has been working. Not in a continuous basis, but he was working.
But in fact, my lord, when the case, my lord, the order was passed, by the time he was not in service, my lord.
Yes.
And
yes.
Not in service.
ବର୍ଷ ଯାକ କାମ କରନ୍ତି, କେବଳ ପେନ୍ ଆଣ୍ଡ ପେପରରେ ମାଇଲର ଗୋଟେ ବ୍ରେକ୍ ଦିଅନ୍ତି, ଯାହା ମତେ କୋର୍ଟ କାମ ପଡିଲେ କିମ୍ବା ଫ୍ୟାମିଲି କାମ ପଡିଲେ ମାଇଲର ମୁଁ ଏକା ହିଁ ସେ ଅଫିସର ଟାଇପିଷ୍ଟ।
That's right. ଆପଣ ରେକର୍ଡରେ କିଛି ଦେଖାନ୍ତୁ ଆପଣ କାମ କରୁଥିଲେ ବୋଲି।
ମାଇଲର ମୁଁ WPC 1097/2002 ମାଇଲର ମତେ ଦେଇଛନ୍ତି, ମୋର ଅଫିସ ଲେଖିକି ଦେଇଛନ୍ତି, ମୁଁ ସ୍କେଲ ଅଫ୍ ରିଭାଇଜ ସ୍କେଲ ଅଫ୍ 1998 ମତେ ଦବା ପାଇଁ କହିଛନ୍ତି, ଯାହାଫଳରେ ମୁଁ ପାଇଛି।
ଡକୁମେଣ୍ଟ ଦେଖନ୍ତୁ।
ଲିଷ୍ଟ ଅଫ୍ ଡକୁମେଣ୍ଟସରେ ରଖିଲି।
ଆପଣ ଗୋଟେ ରିକ୍ୱେଷ୍ଟ କରିବେ ଗୋଟେ ଓକିଲଙ୍କୁ କାହାକୁ ଆପଣ ହେଲ୍ପ କରିବା ପାଇଁ? ଆପଣ ପ୍ରପରଲି help volunteer somebody. Mr. Tripathi, you have to help. Yes, because you are the first lawyer they sent to him. Please help him out. He is not able to. See, the problem is there is a human problem. He has been working. See his days. And on paper there is no continuity. But he is trying to say that I have been working. And he has been paid also. Since in the paper it's not reflecting, therefore he has not been regularized. Find out somewhere if you can get some link somewhere. We'll try and ask them to at least regularize and do something. ଆପଣ ସବୁ ପେପର ଦିଅନ୍ତୁ ସାର୍ଙ୍କୁ।
ଶୁଣନ୍ତୁ ଆପଣ ସବୁ ପେପର ଦିଅନ୍ତୁ, ଆପଣ ଦିମାଗ ଲଗାନ୍ତୁନି, ଆପଣ ସାର୍ଙ୍କୁ ଦିଅନ୍ତୁ ଏଣ୍ଡ ସାର୍ଙ୍କ ଅଫିସକୁ ଯାଆନ୍ତୁ, ଦେଲା ପରେ ସେ ଦେଖିବେ କାଢିବେ, ଯଦି କିଛି ହେଇପାରିବ କରିବା, ଠିକ ଅଛି। Mr. Tripathi is requested by the court to assist the court as an amicus curiae, as the petitioner is not capable of affording lawyer. Mr. Tripathi has gracefully accepted the request of the court and willing to assist the court. Willing to assist the court. Release the matter. You tell me when you want. And registry is directed to supply the entire paperwork to the to Mr. Tripathi. He may not give you proper paperwork. Yes. You tell me.
Next week.
Next week. 11 वाला week. Bar
Yes, one small parallel.
Yes.
That item 73. The personal address 363, 366. That was Passover. So I have some difficulties after launch. Can it be taken to tomorrow? Just parties are present for that reason. If you're not always not after launch, would Passover number data for a case fix.
Call. Yes. Okay. 73, na? The parties are there.
Well, parties are there.
Mr. Raghunath, see. Ask the girl.
Passover matter item 56 for me to withdraw my lord. Item 56. Right.
Yes.
Hundred one is the GAL will appraise your lordship from VC, again recollecting again your lordship. It is for your lordship.
101, na?
Yes, madam.
Yes.
On 23, the GAL was appear when the husband or lordship appear, or the in-laws appear your lordship.
She has got the file.
My lord, item paperwork kindly to come up next to my lord.
You ask for Passover, why should you go? What is this matter, by the way?
I don't have any instruction.
Compliance order.
My lord, I don't have any instruction regarding that, my lord. My senior was likely to argue the matter, my lord. He is unable to come to my lord. Come to this court, my lord.
Where is the file?
My lord,
where is the file?
My lord, the file is with the senior. He is with my senior. He was about to come.
You had not gone to the office yesterday.
My lord, he was about to come today in the lunchtime, my lord. But due to some reasons, he couldn't come, my lord.
But you should have asked what is the case about.
Applause, my lord.
Please, one sentence of this relating to the matter. You are not holding the file also.
I'm sorry, my lord.
Henceforth, you must read it and come. This is the last judgment I am giving you. That request of you. December.
67. Lordship, I have already filed already.
Even the sleep will not. Sleep. Everything else.
Yes.
Kindly have a glass. Kindly have a glass to page 9 of my page 9. Last page. Paragraph 6.
9. Okay. Para 6. Okay. Who the parties shall withdraw the cases filed against them. You tell me when they separated.
Soon after the marriage, they separated. Soon after marriage, after 2-3 months, they are staying separately.
You want that 32. ଆପଣ ଦେଇଛନ୍ତି ଆପଣ ନିଜେ ସାଇନ୍ କରିଛନ୍ତି ତ ଆପଣ ପୁରା ପଇସା ମିଳିଗଲା କେତେ ମିଳିଗଲା ସେପାରେଟ ହେଇଗଲେ
Question of FIR, Section 498, 506.
Notice has been issued. Notice. Non-APS for a private party. Notice has already been issued. You adjourn it on request. Adjourn. Yes.
7. May I please, Lordship? Lordship, as per the direction of the Honorable Court on 26/9/24, I've sent all the documents to the in this case.
Yes.
My lord, mo 26 तारीख रे respondent को सब document पठे दी थी.
There is any problem in sound just yes. What is this case?
My lord, is coming for question of cognizance, my lord, with the entire proceeding, my lord. Under section 498A, 294, 323, 506, 34, related to 4 DP, my lord. And the petitioner is the mother-in-law, my lord.
Service petitioner. You have not filed requisite notice was issued to opposite party number 2.
My lord, mo सब जगह
Notice on opposite party number 2 could not be heard by last opportunity. One more chance is granted to the petitioner to serve opposite party number 2. Please the matter. Yes. You have not serve. Yes.
89.
In this case, 89, 90 and 91. On behalf of Mr. Sahu Magar, taken up on Mr. Magar any day. And the applicant, my lord, has directed to my lord and friend to provide the copy of judgment along with a petition copy. Enter what lordship directed. I have already sought to the council manager. Enter copy. Judgment copy already in annexure. Supreme Court judgment copy already in annexure. Annexure number 6.
Already
Any data.
You are for opposite party.
My lord, I am for the petition.
What is this case?
Well, in this case, Ladan appellate court below Kendrapura has directed to deposit 20% of the ordered amount. To that, I have challenged in my court. And I have preferred the judgment of the Honorable Supreme Court.
Yes.
And also referring to that judgment, our coordinating judge, Justice A.K. Mahapatra, has set aside the order of the Land Court below and directed to file another petition, for exemption of the deposit. So, on the same footing, my lord, you can pass order. Honorable Justice A.K. Mahapatra has watched the similar nature of case.
Where is that order?
My lord?
Where is that order?
I have already submitted to let's say.
When is that?
Again, I am submitting.
Yes, I got it. You want similar order, huh?
My lord, on same footing, similar nature of case. And the lordship, the Honorable Justice A.K. Mahapatra, referring to the judgment of the Supreme Court, has passed such a thing, sir.
See, the court says that while admitting the appeal, he was directed to deposit this thing. So therefore, the notice should be issued to both the party and hear them. That is what is the order. Similar order I can pass. But you can very well.
Mr. Sahu is out of session. So any data next week, any data.
Next week.
And nothing left in this case.
88. Yes. 89, 90, 91. But I will pass the same order. Just Mahapatra has passed the order.
Yes,
I will pass it. Yes.
92. 92 customer kind of likes to be called noting of the cause list. Noting.
Yes.
LCR has not been received so far. This appeal was admitted on 25/9/2024.
Filed a miscase for a stay of conviction matter.
Stay of conviction, I will file objection.
Your lordship just filed.
Why?
Mr. Paddy is informing that.
He is already there.
I will file objection. Last week they have.
But in the according to this case,
He will be losing his job. That is the peculiarity.
one part. Second part, what happened?
In all the cases where corruption case is there,
What happened from the secretary, they reverted in the lawyer post. One part, I am working with all humiliation. Here is the case, the president, the entire body directed me to do so. They plus good vote. That's approved. The president body, it was approved. Then only I will permit you to make the transaction. They implemented the same to yes. On audit, somehow some political anything, audit just find out that generally lordship moves it in any land transaction out of amount and official amount.
Have you prepared a note?
Yes.
You prepare a note, TRC, I will call and I will fix a date for hearing, panel hearing. Get ready for panel.
Lordship will hold without LCR. Yes, sir. Your lordship, I prayed before your lordship to have a glance to the note.
Why are you getting so surprised? Sir, I am calling you.
If it will be fixed for hearing.
See, that is what I am saying. See, if for the purpose of stay of conviction, the amount I will spend in hearing, I can dispose of the appeal itself. So therefore, what I am saying is, let them get prepare the note. I will fix a date. I will call for TCR by the time.
Yes, sir.
And you also prepare and I will hear it for 10 minutes.
Yes. Why is the supply copies of depositions, etc.?
We have the deposition copy and all.
Go ahead. You can supply everything.
No, 5 years also.
Yes. I will sir, find my friend also.
Give it to him.
Yes.
File a copy here and meanwhile I will see if the TCR is called for. And I am fixing, you tell me the date. Fix.
Yes.
You come prepared in the
You must fix them.
11th or 12th at 3:30. 12th at 3:30.
Yes.
12 o'clock, 12th on 3:30.
What I am saying, my lord, because my lord is objecting about this stay, the conviction in respect to may not be effective in running the post of.
No, that cannot be. Your lordship was in no cases your lordship was in.
I will have to pass an order on the stay of conviction. At least that will be 10 to this order I will have to write. Within that 10 to
Said that.
get ready, prepare the.
Yes, I will have a short note with all citations and it's. Everything is the court party are best.
You have a good case, you will get good case.
Yes.
Otherwise,
Yes.
things will pass. Yes.
93.
TCR, Yes.
Kindly the grass to last order, my lords.
Yes.
And last order for my lord has directed me to file any objection if any. My lord, I will file you an objection, my lord. Yes, my lord. Copy. Thank you, my lord. My lord, that
What is concern? You got everything.
I am reading the order, my lord, of my lord's order, my lord. My lord has directed. You will not decide.
How much amount?
Substantive compliance is there.
Madam, let me submit, madam. My lord has passed. I'm going to draft to act order, my lord. My lord has, they have submitted.
I asked you to file objection if any.
Yes, my lord. They have submitted two papers. Placed two papers before this honorable court, my lord. And so far as my objection is concerned, my lord, the part, there was a direction by this honorable court, my lord, for regularization of service, consequential service benefits, and arrears and thereafter pension, my lord. My lord, there are 10 stations. I will work, my lord. After 10 stations, because of my lords, or my lord, because the content is aligned, I have mentioned in paragraph 3, my lord. First, they have made 267 6 days. So for regulation concern, they have made extraordinary leaves, all the extraordinary leaves. Thereafter, my lords aligned order.
You place on record.
Madam.
You placed in record.
But it is.
You place it on record by affidavit. I'll record it in.
My lord, let me say. Only there are, my lord, extraordinary leaves. They have made all extraordinary leaves. There, after my lord's order, my lord, they have made distributed, my lord, that was.
That there is a substantive compliance. I am satisfied. I'll drop it. I can't. It can't go on and on and on.
No, my lord, only one. My lord, they have filed a document, another so
How many hearing this court has given to you?
My lord, yes, I am the grass to
here. I am not here to keep on calculating every.
I am not
substantive compliance is there.
I am not pressing for one substantive objection. If you want, I have already filed objection.
Very well.
Yes, I will give
Online, sir.
just now. And they have also filed a document.
When have you filed?
Just now.
I will record. Just now. Right. Then counsel for the petitioner seeks time to file objection. You file Mr. Raghuda, land counsel for the Mr. Raghuda, land counsel for the opposite party contender states that the judgment of the tribunal has already been complied, substantively complied, and he wants to place on.
So far, the regulation they have not complied.
You file the objection. He wants to place on record the compliance affidavit. The counsel for the petitioner seeks adjournment to file affidavit of objection to the same. This is the matter. Yes.
They have also filed a one so-called
your client started enjoying the litigation.
Not even trying to enjoy litigation. They have the document that was not served. They served to the file.
We'll see. We'll see.
The next that manner.
I will give it December. Yes.
Well, let it come after
December. Yes. Next.
December.
Yes.
Small prayer. Let them take inspection so far.
I will not advise them what to do. They have done their job. And if you are not satisfied, check it.
Oh my lord,
there is a substantial compliance. Everything is over. Every treat and bit
also, final prisoner.
He is in the link now. He is the link. Just check it up with the link. Item number 85. 85. Can you come in link? Just see. What is his name?
Aravinda Panda. कौन कहूँ जॉब साहब
yes Aravinda Panda 90 what is the item 85 okay yes
Please on this is the proceeding. Here a criminal case has been filed which is completely a civil nature.
You are appearing for? Yes.
If your lordship sees the 160 petition matter, that is that.
You have compromise. So there is a compromise. That is a compromise decree you filed.
My lord, that is relating to a partition suit, my lord. That was the first instance where the cause of action came into.
Yes.
My lord, initially the opposite partner two's mother filed a partition suit, my lord, claiming a share.
Are you still interested to prosecute him? Because see, these are the cases of 2015. 2016 stay has been granted by him.
Actually, Lani Senior argued this matter.
See, a stay is operating against you since 2016. If you are asking for adjournment, what can that? Only speaker. Only joint request. On the joint request by the parties, at least the matter on 13th.
Let's entry model to
13th. That is because of the entry model was 2016 is pending. I'll vacate and make it clear.
So I will
That on the next date of hearing with the parties, the matter will not be adjourned on the next date of hearing. The adjournment would be sought by the petitioner. On any count, the interim order passed in the year 2016. When the interim order passed?
That was on 19/9/2016.
19/9/2016 shall be vacated. I'm making it very clear. And a 1cc case pending from 2015, taken a stay from 2016, and asking for adjournment for 1 decade.
Let's say apologize.
And 330 asking for adjournment. Yes.
97th.
Not adjourned like this. Yes.
One password.
The same thing you heard from Mr. Bag is there, he let him start.
In this case, on the last occasion, direction the party to have a settlement, but he is not turning out. The fact remains, by virtue of this order, two complaint cases under 138 of the NIA is being stayed. In one case, it is posted for argument.
You are the complainant.
Yes, total in two cases, 1.96 lakhs. And payment has been admitted in complaint officer, and also that it was paid through RTGS to his bank account from my bank. That is admitted. There is no dispute on it.
Why are you so adamant? Why don't you settle? You are the accused. Our client present today. Why are you not settling? In a 138 case, you have taken a stay from 2016 onwards, and I am giving an opportunity to settle the dispute. Why are you not cooperating?
टाइम दरकार है
ଆଉ କେତେ ଟାଇମ ଦରକାର 2016 ଚଲେଇଛନ୍ତି ହଁ 13 ମସିହାରୁ ଡିଜନର ଚେଞ୍ଜ ଡିଜନର କେ 2013 ମସିହାରୁ ଚଲେଇଛନ୍ତି ଆଉ କେତେ ଟାଇମ ଦରକାର ଆପଣଙ୍କୁ
बैंक इंटरेस्ट का 12% दउछि लेटिंग रेट ऑफ इंटरेस्ट लोन आनी के देछि
ଆପଣ ଟିକେ ଫେयर ହୁଅନ୍ତୁ ଏମିତି ହେଲେ ଚଳିବନି କେତେ ଟଙ୍କା ଚେକ୍ ଥିଲା
ଗୋଟା ହଉଛି 1 crore ଗୋଟା ହଉଛି 96 ଲାख
ବେଶ ଠିକ
चेक टा मोर जबरदस्ती पुलिस स्टेशन नै के पीसीआर रे जबरदस्ती मोर नै आइ
ताबे आपण केस करथिले
पैसा बाकी अछि कॉम्प्रोमाइज कर
ना ताबे आपण केस किस फाइल करथिले जबरदस्ती नै चुली केस हेतला पे
केस पेंडिंग है
तो कोन हिची से केस
एटा पेंडिंग अछि
पेंडिंग माने कोन हो स्टेज रे पेंडिंग अछि व्हाट इज द
स्टेज 974 of 2017 Rasimaganti there he has admitted that this amount is due, and there he has said that he was earlier he had paid 2 checks that he has got vigorous, then there was a settlement to pay. Now allegation is that he was called to police station, from police station the checks were taken, but in the complaint petition he has filed alleging that he was called to the police station and other things. Cognizance is not been taken there, and cognizance is taken only on 467, 468, 471, 420 on these. On those allegations, no cognizance.
Yes, your lordship has already heard this matter on merits matter.
Yes.
On the last,
why are you not settling it?
Yes, correct. On the last, your lordship directed that see to the matter can be settled.
Yes.
I've informed the client he is there before your lordship. He is willing to settle the matter. The difficulty is that there is a NCLT proceeding against us, insolvency proceeding against him. So unless until that proceeding is not withdrawn, he won't be in the position to pay. So far as the check is concerned, who has initiated? By one of the senior client?
Any financial creditor?
No, operational creditor.
How is operation? He is given, he is due to be recovered on.
Winding up proceeding was initiated.
How he become an operational credit?
No, he's a private party.
The private, who initiated section 7?
My level serious client.
Okay. Everything can be settled.
Yes, sir. So everything can be settled. Therefore, my lord, my client was willing to pay the money, but so far as the check is concerned, my lord, admittedly the check was taken.
Not admitted.
One second, sir.
See, on merit is something different.
Yes, sir. On threat and all. So I'm not entering into those aspects, but Lordship has already heard those things. Because the issue involved, so far the legal issues involved over here, my lord, the Lordship has to see whether the cases and the counter cases has to be.
No, I'm not going on to merit now.
Yes.
Now he's calculating, there's a case pending, 138 case is pending, and the insolvency proceeding is pending.
Yes, sir.
So all these things can be settled by, if he is agreeing.
He is agreeing, but the only predicament of him is that so far as the proceeding, the incentive proceeding is concerned, unless and it's not withdrawn, he won't be in a position.
That will be a modality of settlement. First you seek to, try to find out.
Your lordship may settle it here. Tomorrow we will settle.
Yes, what do you want?
Yeah, how do you propose to settle it, sir?
Actually, whatever difficulty you have, suppose any problem is there, and you can tell across the table, so that that problem can also be taken care of. You can, settle the dispute, all the dispute.
And your lordship,
You withdraw the section 7.
he is so powerful, my lord. This honorable court directed attachment before transfer to NCLT, and the liquidator, my lord, has seized it. There is watchman, but he is operating the.
Then both of you suggest, I can appoint some mediator and finish it up. You suggest if you want.
Any person your lordship.
Sir is sitting just behind you, you can help us.
Yes, sir.
You please help us, sir. See, you can settle, you can. Fortunately, he is there.
Fix the date, will appear in his chamber.
Yes.
Then it will.
No, sir will tell which date.
Any date, Sunday, any Sunday. Any Sunday.
Coming Sunday, coming Sunday.
Yes,
Coming Sunday.
Coming Sunday to Diwali पर रहेगा.
You tell another. And you can.
Coming Sunday. Any Sunday. Diwali ପରେ ହଉଛି coming Sunday. Diwali ହଉଛି 30.
Let it be on 11th or Saturday.
And you have to speak to him. His inconvenience is to see. No? You would go to chamber.
Sunday is 10th, my lord. 10th of November.
Sorry, appointed mediator for settling the dispute and awaiting the mediation report. Release the matter. I am releasing it in the after the 3 weeks.
Okay.
3 weeks.
Your date of the will not be listed.
No, date has been.
Yes.
Date has been. After 3 weeks, give a date and interim order to continue till then. And something will come out. You sit together and.
Yes.
Yes.
98.
Yes. May I please? Under Mr. Blessing, the party said, both the parties said mutually agreed to get the matter detailed through Mr. Shakti, senior counsel, who is representing the court, and he has gracefully agreed to the request of the court to mediate between the parties and try to settle the issue. Yes.
98.
My lord, may I please, on behalf of Mr. Piercing, may I be permitted to submit your lords? Yes. My lord, this is the petitioner of the in-laws seeking for the petitioner. And petitioner. My lord, petitioner of the in-laws, the petitioner number 2 is the sister of the opposite number 2 husband. That means the petitioner number 2's brother married to the infant. And petitioner number 1 is the husband of the petitioner number 2, your lordship. Yes. My lord, both are doctor. My lord, what is happening? There is no specific allegation against them. Marriage happened and solemnized in 2005, your lordship. Soon after the marriage, they both the petitioner number 2 and her husband
left for US, Your Lordship. They stayed in US.
Yes.
Till 2009, Your Lordship. In 2009, she returned and got a job in Hyderabad, office partner too. Thereafter, she left, quit that job, then come to Odisha. Thereafter, again, she returned to Hyderabad. There also, thereafter, she went to UK. So, her husband was staying.
Husband means Pandna.
Yes, Your Lordship. Her husband of pitch number 2's brother. Pitch number, this pitch number, there is no specific allegation against these people. My lord, they, at the time of marriage, the sister was already admitted to MBBS. She passed out after 6 years, 11. Then the petition number 2. And then someone one married to petition number 2 in 2009. There is no, and both are doctor, Your Lordship. So, both the petitioner are doctor, Your Lordship. They are the allegation in the FR. There is nothing, no specific allegation. If Your Lordship may kindly turn to page the 28, Your Lordship.
Yes.
28, that is, sorry, 27. Only that one extra, I was physically, mentally tortured, assaulted, humiliated by my husband, all my in-laws, such as my father-in-law, mother-in-law, elder sister-in-law, and younger sister-in-law. And husband.
You are younger sister-in-law.
I was the younger sister-in-law, my sister-in-law.
Okay.
This is much allegation. Your Lordship might know that lots of there is no role. Your Lordship, the recent judgment.
Who is petition number 1?
The husband-in-law and petition number 1 is the husband of the petition number 2.
Huh? Petition number 1 is the husband of the petition 2.
Yes, Your Lordship.
Okay, then okay. Sister-in-law's husband.
Sister-in-law's husband.
Okay.
Sister-in-law's husband.
When this they married?
They married in 2009.
When the opposite party number 2 married?
In 2009. And thereafter they left in the effort itself. She has narrated all the stories. It's a lady left.
There is specific allegation against the present petitioner.
What specific?
Regarding torture and demand of dowry.
What is that?
That is mentally and physically that has been.
No, general sentence you don't.
No, general not. It's not.
And you say that you torture.
No.
Also, apart from the you prosecute, you give husband, you do whatever.
Yes.
She was a doctor studying.
Yes.
Sister-in-law.
Yes.
And she also married somewhere else.
Yes.
But you have not left to her husband also.
No. Lord, in this case, my lord, the present petitioner being the in-laws, my lord, they are specifically the statement.
Petition number 1 is not in-law.
Yes.
Petition number 1 has married to your sister-in-law.
That is sister-in-law.
Who belongs to some other family. You are prosecuting him also.
No, after marriage, my lord.
Everybody is related to the husband you will prosecute.
Yes, husband.
What is that? No.
Husband also. And
inform me the allegation against these 2 people.
yes, my lord. That is 27.
You prosecute your husband, do whatever. That Lord, independent witnesses, they were stated that the charge sheet witness, Lord, they have categorically stated that
This petitioner says harassment.
should be what are the,
That is their.
what kind of harassment?
Yes. That case 27.
27
my lord.
27.
I was reading.
That I was physically, mentally tortured, assaulted, and humiliated by my husband, all my in-laws, such as my father-in-law.
Specifically, such as everybody.
No. That apart, Lord, and her husband, Chinmay Panda, the present petitioner, in different place. That apart, my lord, I am reading a statement of the independent witness, my lord. That one.
What is the specific allegation? What torture means? What torture? Demand. What way demanded? How much he demanded? That is demanded. That is demanded dowry.
No, that
Then he has to go to jail.
amount of 50 lakhs was demanded by the.
Where is that allegation?
That is there in the paper itself, Lord. And that apart, other witnesses.
Everybody started asking demand. Just in chorus, please give 50 lakhs.
That apart, Lord, the other witnesses, independent witnesses, Lord, they have categorical.
Show me.
That is there in the statement.
Yes.
State comes
against what are the specific allegations against these 2 people? And these,
Following the way, in 2005 to 2016, they were abroad, Your Lordship.
are you so sure that you want to prosecute this is the 2016 case? What are you doing by the way
That
now?
is pending for court.
What are you doing by now? You might have been settled in your life.
None, I was not sure.
Now, right? I didn't what are you doing?
Still unmarried.
Where?
No, I was still independently I am living.
Divorce has taken place.
No divorce.
Have you drawn up any proceedings?
No, I have not done.
Your husband is
The proceedings is going on.
going on.
It is the recent judgment of Supreme Court. Is
No,
covered by
there is no
recent
allegation
judgment.
that-
Your Lordship knows that there was a judgment.
Show me specific. Interim order operating?
Yes, yes.
Let it come in December.
But last day also, you will also see that I have started given that judgment. The court directed that to go through the judgment and the come to that. You will also
Let it be, she is enjoying the litigation, let it stay with the
both are in now I have the serving in Chhattisgarh, Your Lordship. Because of these cases, actually, these people are also not because they are doctor and Your Lordship may kindly see the life of their now.
But what to do, you have to assist me, I can't keep on searching.
I'm saying Your Lordship, he is saying allegation is this not Your Lordship.
Show me the evidence, none of you are able to show me the evidence.
My lord, if Your Lordship will see that only omnibus.
Don't tell me the general. My lord, I'm saying Your Lord. None of you are getting wasting time.
I'm giving the document.
So,
I'm reading the information.
Well, I'm reading the in the 11th one weekday. By now, I would have decided. My lord, you are giving a speech.
No, my
evidence.
I'm reading the information.
11th one weekday.
99.
If there is no allegation, specific allegation, I believe his husband, whatever.
I'm not before your judgment is not before your Lordship.
Yes. All of you. How many matters total? It's called.
That's it. On 11th, Your Lordship.
11th one a week, anytime. 12th, 13th, whatever. But come with the document, don't waste time.
No, I will just the information statement and all the statement. Yes, I will keep it because.
Yes.
In order to continue, my lord, in this matter.
Yes. 99.
Item number 99.
And then IIC asked for 1 of time to file the approval, also directed it. So 1 of time IIC is asked for.
My lord, may see the order date 7/10/24.
Yes.
Final opportunity was given. Apparently order was passed. What is the problem? Despite a peremptory order was passed on 7/10/2024, the IIC, yes. It's not filed. It's not filed the response. Mr. Patra, counsel for the petitioner, submits that the IIC has requested for 1 week time as the last opportunity. Regarding that to the request made by Mr. Patra. 1 week is the last and final opportunity granted to the IIC to file the response, list the matter. One week, 11.
If I may submit, my lord. My lord, the IIC bank is constantly calling the petitioner and harassing her. That because of this case, my lord, and he hasn't filed any final form. And he is constantly calling the petitioner and harassing that he
has already filed the final form.
He hasn't filed. So,
Well, she filed affidavit. I can't say if anything of that sort is done, file affidavit. Yes. Maybe he is calling to file a response in your favor in exchange of something. You are not understanding the indication. You are complaining. Yes.
Yes, sir. This case must have come up against the refusal of the Learned Trial Court to take cognizance in a complaint case.
You are the complainant.
Yes.
Yes.
You are the sure.
So many material.
But here the facts are like this. I purchased huge quantity of cashew nuts from the opposite party, CORAM Cashew Limited. If your lordship will kindly peruse two things which will going to perhaps of the case. The lordship may kindly turn to page 37. 37.
Hey, come to the protest petition and show me the 202 statement and option. If any case is made out, cognizance has to be taken.
Protest petition, on the basis of the protest petition, cognizance has been taken. That cognizance became subject matter of challenge before the revisional court. The revisional court set aside.
That way.
Show me the revisional court order.
Cognizance order, how cognizance order has been.
Page 91, I think that order is there.
Let us come. What is the reasoning?
Your lordship has to
against cognizance order, revision lies.
Yes, ma'am. Your lordship can see the facts first.
First,
no, let us see the facts. What is the facts like this? Peculiar facts your lordship will first find from the receipt itself. Your lordship kindly turn to page 37.
37?
37.
Yes.
He issued a receipt, invoice number 6 on 5/12/2017.
Okay.
Then if your lordship will kindly turn to page 39.
Yes.
The invoice number 7 is dated 10/12/2017.
Yes.
And 10/2, sorry, 10/2.
Yes.
The first invoice is 5/12. Second invoice, which is the earlier date. 10/2/2007. This shows the manipulation. And then he has tried to manipulate the things. The facts are like this. I purchased huge quantity of cashew nuts to him. He is a registered dealer. I am a registered dealer. So this is according to the sales tax law, which I have understood from them. I know little about that. It is a B2B sale. So B2B sale means I get some advantage. Some advantage he gets on income tax and all that. But he has manipulated and manufactured B2C deals as if I am not a registered dealer, I am a third person, ordinary purchaser. That is first nuts. He has taken money, he has not given me any goods. That was the complaint. If your lordship will see, another thing is balance sheet at page 35.
Yes. Yes.
He has issued so much bills to me, but he has shown left side mirrors. Yes. Current liabilities and provisions. He has shown from me, he has received 40,803.
Yes.
Whereas the amount sold to me is about 18 lakhs or something like that. So this prima facie makes out a case. But the Hon'Ble trial court, revisional court, without going into those facts, and just
these documents were they part of record.
Yes, these are all power of record. I need to learn. They are power of record.
In the complaint, protest petition, have you filed the documents?
Can I see the LCR?
No, in the complaint petition,
verify the LCR. I will, it will be there, I think. Complaint case.
That should be the first thing you have to tell me. If you are relying upon some document on the basis of which the cognizance is taken, whether that is part of the protest petition.
The lordship may call for the LCR. LCR has not come.
Is it the part?
May I just explain? Must they file an FIR? I'm taking
investigated, close the report file.
I'm just taking lots by Lawrence. The lordship can have that page 32.
32? Yes.
Page 32 is the balance sheet for the year 31st/3/2017. So I admit these liability to be 19 lakhs.
19 lakhs.
So kindly see in the current liability provision, the lordship saying Kanduli Kaju is 19 lakhs. I'm just 19 lakhs. So I'm a cheater, I'm admitting in my book. Now, my lord, in 2018, I reduced it. That's the allegation, my lord. I'm not running away. It reduced to 40,000 in 2018. In between, all these transactions occurred, your lordship, that bills your lordship have find out, 5, 12, 12, 12. So all these Kaju have been supplied to me. The mistake, I have also reflected in the GSTR portal. What has happened actually in the transitional period, it's in 2017, the GSTR came, consultant, instead of throwing it B2B sale, means business to business sale. Had it been a business to business sale, then the input tax credit would have been according to them. He has done it at B2C sale in the GSTR code. That is also investigated and found to.
And one thing,
And the police has made a detailed investigation. And also can have everything has been reflected. The balance sheet figure has been reflected. All these things, my lord, whether I have supplied the Kaju,
the very fact, lordship and see the receipt.
yes, receipt.
GST of manipulation. So I am saying.
39. Yes.
That I've seen, that I've seen.
That is 10, my lord.
So 10, 12, GST has not come.
Yes, GST has not come because
How did he get the GST bill?
no. GST I have
That's so purposefully manipulation everywhere.
It's a B2C sale. Business to customer sale has been reflected in the GST portal. Instead of business to business sale, that I'm admitting.
No, but at that time, no, the GST was already there.
Yes, no, GST is come from 1/7/2017. 1/7/2017, and its transactions started 7.
It is the bill is 10 to 2000.
10, 12, 2017.
It is 10
Plus you kind of.
but kindly see the date.
10 to.
10 to.
Here, law.
I just must be get
Very good original. It is there.
Original, there is there. Your lordship can see that. Your lordship. This is invoice number 7. This is 1012. Invoice number 8 is 1412. So it is a purely civil case. Had he received, my lord, total amount is 33 lakhs that I am admitting. I have shown in my books of 19 lakhs. This 19 lakhs they are asking that I have cheated them.
There is some
Have they initiated any?
Absolutely. After time, I initiated this criminal proceeding. And this is how,
Court has not been filed recovery.
no, my lord. And this is how these documents which are otherwise.
Let us see the engine order now.
So investigation, man, I'm just before that, I'm showing that page 70. Page 70, your lordship can have.
70?
70, yes, my lord.
Yes.
This fact is admitted, my lord. It starts from page 69. From the statement of the witnesses and the evidence, it is ascertained that the complainant Kanduli Kaju has made payment of rupees 37 lakhs to Sriram Kaju in 4 RTGS to purchase 36 tons of raw Kaju. On 23rd March 2017, Prashant Sahu had supplied 14 tons of Kaju to the complainant, whose cost is 17 lakhs 93,000. As the complainant was not happy with the quality of the raw Kaju, hence both decided that the complainant will receive the finished goods from Sriram Kaju against the rest amount from 5/12/2017 to 23rd March 2018. The complainant has received the finished good, that is the Kaju from Sriram Kaju, in 29 installment with cost of rupees 18 lakhs 65,080. After receipt of the such amount of goods, Sriram Kaju, the complainant further did not went to Sriram Kaju. As per the report of Deputy Commissioner City GST Puri Circle, Sriram Kaju has paid GST against 29 bill in BC mode, business to customer mode, instead of B to B. Well, the mistake of this nature is there. As a result of which the transaction of Sriram Kaju and Kanduli Kaju is not showing, but the tax has been received by the GST for 29 bill, the complainant received the kaju of cost of rupees 17 lakhs 93,000 with the finished product of cost of so and so, so and so. So this is how the investigation ends. Now, my lord, the complaint has been filed. The complaint case is rest on that 33 lakhs he has paid, 37 lakhs he has paid, 19 lakhs yet to receive. So, my lord, once he says that for kaju I have taken the money and I have given them kaju, where is the 420 and other allied offence comes? Your civil case. Recovery can be initiated against me, if at all. And this is the protest petition, my lord, at Annex 4, page 72. The same thing has been repeated, not a single word how this investigation is wrong. Now, my lord, the reply of the GST authority. Yes. That your lordship find out from page 34.
I find everything, no problem.
Page 34 starts from page 33. During course of verification of serum kaju product produced 29 numbers of invoices against
come to page 73.
My lord.
Para 3.
Yes, sir. Accordingly, the purpose of performing the terms of the contract is, and part of the complaint, and he paid the payment of contractual amount of 37 lakhs to the accused person for supply.
Yes, how will you, sir, how will you answer it? It's pure contract. Your protest petition, you say it is a contract arising out of a contract. And some wrongly or rightly there is an investigation and it is affirmed by the police on the after investigation it is a contractual obligation. How will you maintain a criminal case? That's your own admission, para 3.
Well, yes, I have seen that.
Yes.
You have camouflaged everything on that paragraph.
Contract means not understanding. There is no deed of contract. There is no deed of
business. The protest petition itself says it is a contractual obligation and he could not comply the obligation of contract.
He admits he has done.
It will not preclude you to
purpose of contract. Limitation bar.
Yes.
Limitation. Why don't you settle?
But we have already paid everything. No. We have shown your lordship that all these bills they have received the quantity of.
You have a very difficult case.
I will satisfy lordship. They are not so. I will check up this.
See, in the convenience says, I have to see the protest petition, that is a complaint, and the statement related statement. You yourself say it is a contract because you expect that.
It is not done to understand what is the word to be used. It is a lawyer's mistake.
But I have to go by
let me go through and I will satisfy your lordships. There is a word contract is a misnomer there.
No, complete your specific admission that it is a contractual obligation.
So that is
the contractual obligation.
Contract means maybe that there is an understanding between the parties that in that context it has been used.
And you say it is during the if the failure on his part to perform is part of the contract. That's what you say specifically a word. Then your case completely goes with that para 3.
I will check up and I will try to. I will go through the entire book and that. Because the wordings, people side, these business people, one doesn't know law about the law. The lawyer's mistake, they suffer.
I believe a lawyer has drafted it.
Both way. The way it has been drafted is a lawyer.
And through advocate. Let's see, come to page 77. Come to page 77. Complainant through counsel. It is the burden of the improvised version of the complainant through the lawyer. Even then you could not make out a case. Therefore, rightly the convenience is not taken. Wrongly taken, reversed by the appellate court, revisional court.
I will check up the yes.
Oh, couldn't part.
Any day you're automatic.
Yeah, because I read it now. 13th. It's a part that I have satisfied, otherwise I have to dismiss it. Okay. 13th. Yes.
102.
Yes, sir.
102 main.
It's a case arising out of complaint case, my lords.
Yes.
If your lordship remembers, the lordships have directed this matter for mediation, my lords. So that flag D. Order, my lords.
Flag B. D.
Flag D.
Okay.
Flag C.
Yes.
C mediation report dated 27 and 20.
What happened? Successful?
No, my lords. The opposite party have not turned up, my lords. The entire amount has been cleared. So the sugar mill actually, my lords, that has been closed. The opposite party here is the Burger Cooperative Sugar Mill. OP2.
Manoj Verma.
Yes. What do you say?
Chief, open page appeared Manoj Verma, A.K. Raut, K. Jetty.
No, last time also nobody appeared for.
But in most it is showing
103. My lord, his name is on 103.
What 103?
No, not in this matter.
But it is the state would say it is. 103.
What to do? Is it 138 okay?
Yes, my lords. My lords, the entire amount has been paid back, my lords.
How will you certain that in this document?
Without them, it cannot be said.
Unless the opposite party complainant comes and says that yes, it is paid. How will I believe it? On that basis, how can I quash a
Sir, I never
into 138 already you show and satisfy me that you have paid.
My lords, if your lordship may kindly come to page 5.
If you don't show the statement, you show me the document.
Yes, my lord.
That you and that all this thing has to be transacted through bank.
Yes, my lord. The outstanding amount is 27,66,123.
That is the check amount.
Yes, my lord.
Yes.
And it has been reduced to 10 lakhs before filing of the complaint, my lords. Then some amount have been paid and 6 lakhs was the outstanding amount at the time of complaint. If your lordship may kindly turn to page 5.
How will I get all that?
Minister 4 series, my lords. Minister, attach the checks that you have paid, my lords. And Annexure 4 series, page 24. The checks have been attached, my lords.
No, this check is paid to the towards the discharge of the liability arising out of the check which is do not. Show me that. You might have having any transaction. How do I know for which transaction these payments are made? Unless this check which you have paid is linked to the do not check. Show me some semblance of any document saying that towards the satisfaction of the do not check, I am paying this much. Something of that sort. Otherwise, I am not going to have a conduct a trial. Or otherwise, you bring the opposite party number 2. He should say, yes, I have received it. These are the two options.
My lord, actually, the problem is here, my lord, she is not turning up first, and second is, my lord, there is a bulk of checks. If your lordship may grant some time, I will produce the original checks because in the mediation process,
I don't think I have.
No, my lord, if your lordship,
I don't think I have jurisdiction to do all these things. You want me to see the original check? You want me to evidence everything in 482 proceedings? And you go and tell all these things to the trial court. Trial court will help you. What can I do? Technically, you are in trouble. In a 482 proceeding, I will see all the documents.
and evaluate the veracity of those documents and let it go.
Your lordship,
And if that means the absence of the complainant.
I will produce if the statements, if your lordship can.
What you do is,
Yes,
better that you should go to trial court. I'll record everything and I'll relegate you to trial court and file all the documents and I'll expedite the trial.
As the last
That is the only way
chance, kindly keep up to the last chance. I will produce the statement, my lord. Where the trial court records, I will produce, my lord. I will satisfy.
Trial court records what?
If the statement has been recorded that they have accepted the money or the checks, I will produce, my lords. If your lordship may
Have they made any statement to trial court?
My lords, I think, my lords, I will produce that, my lords, if that has been.
I am asking whether they have made it or not. Produce it, no problem. But have they made it? If they made the statement that yes, I have received the money, then I can drop
take
the
instruction regarding that.
You're not sure. You are the only one. You want an accommodation, but you tell me something. I will accommodate you, then that's not the problem, but you don't have that kind of document. I know. I'll put it next week. We'll just check. Otherwise, you will find out some way out so that I will relegate you to the trial court and record everything. So that you can persuade the trial court and get something. He is not cooperating here. He is not coming. He may not come there also. The complaint will be dismissed on default. And we will be out. Okay.
Yes, sir.
Next week. Huh? 5th.
It's interim order to grant.
Till 5th only. Okay.
103.
103 minutes. The lordships were pleased to issue notice in this matter, granted interim order. I'll get ready with this matter to assist your lordship. Your lordship will call this matter on any day.
It doesn't suit you. You are always ready.
Yes, then
that means you don't have a case.
No, that is not the case. That is not
Yes.
No, I'll satisfy your lordship. In fact,
you already won. But by last opportunity I am giving.
Yes. This is coming up only for the second time.
Yes.
After notice.
Yes, therefore.
And the change of guard. The earlier counsel, unfortunately, we lost him in the bar. So,
okay.
So I'm appearing
1 week after the weekend.
Well, can it be subject to your lordship's convenience? Can it be in the week commencing 25th?
What do you say, sir? The opposing counsel is yes. On request, it's clear that no further adjournment shall be. Yes.
Because there's a interim order.
Interim order to continue.
Great.
Yes.
104.
May I please, well.
Item number 67, the petitioner received the 15,000, sir.
Where is he? Yes, or what he received? Oh, made to sign? Madam, have you received?
Yes.
Okay. Hello. Yes. Yes, sir.
On behalf of Pujari sir, my letter busy for another court.
I on request. Give a date. Yes.
My appearance may kindly be noted, Your Lordship. I am for the Gosala, my lord.
Engaging counsel, my lord, Mr.
107.
10, it is 104, my lord.
You have written 107, Justice.
My lord, 107 is also there, my lord. Sorry.
Are you sure that you are in 104?
Yes, 104.
Yes.
105, my lord, Mr. Pradhan is in, another court is in. So far, kindly be pass over one. Pass over, my lord.
One cannot be possible.
Lordship, I am for the enrollment, Lordship. Lordship, kindly be taken up next week, Lordship. Mr. Chand is appearing in death sentence reference, Lordship.
So 1 week after the next week. Okay.
106.
My lord, I'm challenging annexure number 4, my lord. Annexure 4, my lord.
Yes.
What is this?
My lord, the petitioner,
Who is Vigilance Council? Who is appearing? Hmm? Mr. Mahanan, Vigilance, Mr. Das is there. Vigilance.
search her.
RLMC,
Ah,
Mr. Mar, perhaps in court number 3.
let us see what this is. Yes, yes, madam.
My lord, the petitioner has been charge sheeted along with 10 others in a vigilance case number in Barampur Vigilance PS case number 29 of 2005.
Your
So the-
discharge application is rejected.
My lord, the discharge application.
39 application is rejected.
My lord.
Yes.
My lord, there is absolutely no prima facie material against the present petitioner, to be very specific, and
Charge has been framed.
no, my lord.
There is a stay operating.
Just stay over.
Yes. Yes.
So, my lord, the
Mr. Mahanan.
allegation.
The opposition is not there. Who is next week? Next week. Next 14. 14? 13 to 14.
May I pray, my lord, 13 will not be available, I'll be. For next 18, 19, 19.
Non-appeals for opposite party number 2.
Oblige, my lord, interim order is there.
The interest of resident. Interim order.
Interim order continue, my
I
lord.
should ask him whether you are not appealing this pattern.
My lord, I'll pray interim order to continue.
Interim order.
Here in this case, one occurrence,
47.
yes, 4 check has been issued.
Yes.
For your lordship, another 2 is maybe pending before this honorable court. That number is 2727 of 23.
Give both the numbers.
Yes, I'll.
List this matter.
2727 of 23 and 2726 of 23.
Please, sir. Along with this.
It means after a interim order to continue.
Interim order.
Okay.
My lord, I am objecting the interim orders. My lord, a matter pending since 2023. It's about check it amount of 15 lakhs. Another is 20 lakhs. Another is 15 lakh. Another is 32 lakhs. Your lordship. In this matter, they are.
What is the stage of the trial?
My lord, they challenge the cognizance order. They challenge the cognizance order. I am for the OP party, OP2. I am the complainant, my lord.
Have you moved the application under 143A?
Your lordship, they have not replied under the provision, my lord. Your lordship passed one order in CRLMC number 812 of 2024, Akshay Kumar Naik versus Srimati Swarup Subhadarshini. That is clearly applicable in my case, my lord.
Where is that order, Justice?
I have filed through memo, your lordship. Your lordship passed this reported order concerning to the 138 proceeding matter.
Where is that order? Show me that order.
Memo is already filed, your lordship, and the order.
What is that? Which one?
Akshay Kumar Naik versus Srimati Swarup Subhadarshini Datta.
Yes.
I will file again, your lordship. I filed.
You are arguing something without giving the documents and all. But that will not see. Both the matter. You list it after 1 week or so. We'll see.
Grateful.
But that will not preclude you to move application under 143 capital. You move the application at least.
Because stay is going on, my lord.
I'll clarify the later bit.
My lord.
Stay doesn't mean that you can't move application. You can move application. That will be independently decided.
Yes.
The right to move application under the mandate provision can't be taken away.
Yes.
Let him move application.
My lord.
At least a part of the check amount he may get it. You never know. Yes.
Interim order to continue.
Interim order to continue. And give a short data. 8. Come, get ready. See, 138 cases, it has to be concluded within 6 months. And you have taken stay and pending.
money with the bank manager. He has not given the land for which I have given a letter to bank stop payment. The check was not bounced back.
Stop
Yes, stop payment. And he has not given the land for which I wrote a letter to bank to stop payment.
No, that is.
That is the problem.
Why don't you say, why don't you settle? Yes, Mr. Sahu, will you settle it? Why don't you give the land? You have taken the money.
My lord, we are ready for the settlement, your lordship.
Yes,
The facts of the case is he has given a check. The check would have been realized subject to the land is transferred to him. You don't give the, he has the money in the bank.
No, my lord, the land value is not what they paid, your lordship. The land value is sum of crores.
You paid him, give the land and take the money.
It is with respect to business transaction, my lord. What the learned counsel stated, that is not the fact. I will satisfy my lord, your lordship, previously.
Will you go to the mediation? I'll send it.
Your lordship, in the four matters.
Yes.
I don't think there is a big issue. You can sort it out.
Yes,
In mediation rate, which are all the four matters.
Big pardon.
Mediation rate and the dispute is arising out of complaint under section 138 NIA, and therefore the matter could be settled through mediation. The parties have agreed to try for mediation before High Court Mediation Center, High Court Mediation Center, and same more. Awaiting mediation report after 3 weeks. Entry mode to continue.
My lord, tag four matters, your lordship.
4 matters and all the 4 matters. You want to try if we can settle by now. Yes. My lord, this is a deleted filing of the TDS LOC. Deleted filing of the TDS return. It is been deleted, your lordship. It is squarely covered by your lordship judgment. So it has been paid, your lordship. It is of the year 2010. It has been declared in 28th of December 2000. Squarely covered before Mr. Keria was now he is not allowing you to get it covered. Right. So it has been depleted, your lordship. It has been depleted. Tax has been depleted. It's only a SLP against this order is also dismissed. My lord, SLP against this order is also dismissed. Then become confirmed. Yes. Yes, Mr.
Your lordship, in this case, he has prayed that interest will be paid.
No, it is not.
Only he has paid the tax amount. Interest he has not paid. Further, on 17th October 2024, government has issued a guideline. When CBDT has issued a guideline, ease of compounding. Let him go for the compounding.
You should give me that. Because there are a couple of matters I have reserved. And you give that and you file a reply also.
Already we have filed a reply.
He is not deposited in the interest part.
Yeah, in his prayer itself, he has mentioned that we are not paying interest.
Because otherwise they will take the tax, they will not take unless I will pay everything.
No, this you are covered by this case if you pay along with the interest.
Yes, it is because I went to them, your lordship, I went to them that
get me that.
Suppose the tax is being interest is there also, they'll say if it is there. I think that no
interest not no.
Interest is there. Let them say it's the interest.
You just tell me the interest part. What is the interest component and give that circular.
If interest company is there, I will pay definitely.
Let him give that circular. If you covered by that circular and take note of that.
My lord. It's a very small amount. It's not a substantial amount. Your lordship.
So this is wastage of judicial time also.
Yes, sir.
Nothing will happen. Again, I'll send it to the High Court. There also in the compound.
This matter cannot be a couple of hearings has been taken. Your lordship from the very first day it's assigned you.
Let him give that circular, new circular, he's saying, to 24 circular. Let us have the idea of that.
Yes,
I'll put it. Entry mode to continue.
And let them say the interest and interest. Because I
interest also please verify.
If your interest is not there,
yes.
My application for discharge was rejected. First, prior to that, my lord, I have approved this Hon'Ble case.
This honorable court passed the order, Annexure 2, saying that all the questions that have been raised, that will be dealt with by the trial court.
Yes.
Now, when I raised all these questions without considering the same, it has rejected.
Yes.
The main question was that without a valid sanction, whether the proceeding can be maintained or not. Lordship, last time, Lordship passed two orders. First of all, the order that the 5/7/2024.
5/7.
5/2, sir. 5/2,
Yes.
2024.
Yes.
That is the extensive order. By dealing with that, Lordship has been pleased to stay further proceeding of the case.
Yes.
Because the punishment is stringent here. Under the Act, punishment is stringent. Therefore, the sanction is to be considered by the court before proceeding. That has been dealt with the Sibo Sankar case. That has been quoted in the order. And thereafter, the Lordship, the last order wanted to know whether the question of validity of a sanction can be raised at the stage of discharge. That was the last order. Now, the Lordship also asked me that some judgments, rulings are available. I found without rulings are available, the question of validity of sanction can be raised at any stage, even after taking cognizance. There are two judgments. That is the stage, Here, unless the valid sanction is there, the whole proceeding is vitiated. That is the ruling of the Supreme Court. That is why I stand,
Yes.
Therefore, the rejection order had Annexure 1 and the entire proceeding I have prayed for passing of this same. Now, for getting a valid sanction order under the Unlawful Activity Prevention Act, Section 45 comes into force. It said that sanction has to be obtained by the competent authority, and that too within the permissible time limits. It cannot be done that sanction will be taken up without applying the mind of the independent authority or beyond the time granted. Hear me, Lord, this question I have raised before the trial court. Specifically, that has not been answered.
Let's see the impugn order. Impugn order.
Impugn Annexure 1. Yes. Annexure 1 page 150.
There is the record. Para 3.
Yes.
Para 3, there is the record.
There is the record. The present case, charges under section so and so has been answered, so and so has been submitted against the said accused persons. From the materials available on record, FIR, charge sheet, statement of witnesses, so and so, under a connected reports available in the case, record clearly shows that the complicity of the accused persons in the alleged offence under section so and so, IPC and 17 of the Criminal Law Amendment Act, section 16, 17, so and so, Arms Act, and so and so. It has been clearly highlighted in the case of Center then so and so that while extending jurisdiction under 227 CRPC, the magistrate should not make a roving inquiry into the place and into the pros and cons of the matter and weigh the evidence as if he was conducting it as the law. So the point of discharge has already been settled in catching of distance of the apex court, giving suspicion of the sufficient to frame charges against the accused. The above proposition law finds support.
Where is the finding regarding sanction?
No find, nothing. And my specific
only attack is sanction.
That is
the trial court doesn't deal with it at all. Trial court has gone on merits. He said that this court will not go into the pros and cons of and veracity of the evidence and all. To that extent, the trial court is correct. But he is attacking on the ground of sanction. Where does the trial court deal with it? His only point is sanction.
That is the main point.
That was they are not there in the
Petition is there, specific in that.
Where is that, sir?
But petition, where is the page 93 Annex 8? Annex 8, page 94 specifically, One point is that co-accused person, this petition was never produced to court in time. This is a very long case.
Use only sanction point where.
Sanction point is there, sanction point is there.
Para 7, 95.
Para sanction, yes.
95 para 7.
Para 6 also.
Para 7.
Para 7. That the Honorable High Court also gave the
No way if a prior sanction is required under section 45 of the this is your reply. But trial court doesn't deal with it.
The Honorable High Court earlier also specifically stated to raise all these questions. So it has to be dealt with, Milan.
Yes. What do you say?
That is there in the my concern. Though sanction not receiving lot, but that not initiate the trial.
No, that is a different story. But if he that is on the ground of the sanction and the earlier round also he raised all these points.
Yes, yes.
Only sanction point.
Yes, yes. And Subhati Panda case, it said that relying upon a Supreme Court decision, this court held that only quoting the decision that without a prior sanction, the entire proceeding is rejected. Because see, sanction is given looking at the punishment. He has quoted what the discussion was made in the parliament, why independent authority was appointed to review the matter under the specifically under the Unlawful Activity Prevention Act. Because the punishment is severe. Death punishment is there also. So unless that is followed in law, the entire proceeding is rejected. That's it, my
what do you say? But see, the trial court apparently in the impeachment order has not dealt with it all. So therefore, my proposition is set aside and send it back.
That can be also. Only with a specific.
No, I'll hear you and do it. I'll not.
Yes, but
I'll put it next week or yes. And if you can justify, it's all right. Otherwise, it is a matter where it to be set aside and send it back to the trial court for
to consider the validity of the sanction part. As per the provision. That will suffice. There is no way of delay.
Let him be satisfied.
And interim order to continue.
Interim order to continue.
110.
And read my earlier order in the same proceeding. There I have, formulated the question kind of.
24.
110? 90 euros. Yes, sir. Your lordship may kindly recollect. On the first day when the matter was taken up, your lordship was pleased to take note of the fact that the father and mother who were put to trial, and in fact the prosecution witnesses did not support the case as a result of which there has been an order of acquittal. In order dated 27/8/2024, your lordship has been pleased to take note of all those facts and then granted me protection. And in fact, since the State Council appearing on that day, my friend Mr. Robert wanted to go through the judgments and everything, matter was deferred. I have filed the copy of the judgment and the depositions. Your lordship will see the near and dear everybody has disowned and they have been declared hostile by the prosecution. So this prosecution which is split up will be a futile exercise and wastage of valuable time of the Honorable Court. Not only that, during the pendency of the proceeding, the parties have compromised. Now, I will not say that the compromise itself will be a ground for passment, but factually they have compromised and this fact was intimated to the police also. The only thing which was coming in your way is you were absconding. I was not absconding, that you have explained in para 4 I have explained. Exactly. Not only that, in my petition also I have stated I was all along available. And in fact, when I was engaged and a memo was filed for listing and why the matter was not being listed, we found that it has already been dismissed because the one senior late Sri R.K. Naik was appearing and he passed away on the list. Yes, that was the situation. There we I have given to my friend the depositions and the judgment itself. And in judgment, your lordship will may kindly peruse.
His husband.
He may be the husband.
Husband always in a different footing than others.
Many times there are good husbands also.
Yes, sir, there.
Good husband don't do anything and the in-laws also do. And he doesn't appear for bad husbands.
Yes, how judgment are available, even if not, others are acting. But that does not mean that husband automatically
That's the general principle. But you have to take overall this thing. He is what are the allegations, specific allegation, which is different from the allegation against the parents of this petitioner. That has to be seen. Those people are acquitted. If he is put to trial, whether it is a futile exercise or not, that has to be examined. Simply you tell me what are the allegations against him and what is the allegation against and what are the findings by the trial court. Well, assist kind submission only one more thing. These depositions, they completely say that we have not been examined by the police. So are they going to say against me? That will be another aspect. The witnesses say we have not been examined by the police at all. They have been declared. There is no 161 statement. So there is no investigation in true sense. In that sense, charge sheet is filed in true sense. Never if their evidences are taken to be correct. And if the trial court has taken it to be correct and therefore equitable order is paragraph 20 and 21, page 15 of the judgment. Yes. It is found that there was in demand. That is the finding. So page 15. Page 15 of the judgment here, I have filed at flat B. Yes. I could not say that, but in fact, but for the fact that my friend was appearing for the state to go through the things it was effort. Otherwise, possibly this matter would have been disposed of 2 months back. That's the reason they strategically changed the law. And my friend Mr. Rao was appearing. And now, I'm not in that, right? We are assisting your lawsuit to arrive at a just conclusion. I will not say that because what are the findings? The lawsuit kindly to
last of the file also direct of the case date. We have got treated worker received the case date.
case diary ଆଉ 161 statement ର କିଛି value ରହିବ ଏଇ deposition ପରେ ତ ଆମେ ଦେଇନି statement hostile declare କରୁଛୁ prosecution 2021 finding ଟା ଆପଣ ଦେଖନ୍ତୁ ଖାଲି well let me kindly peruse ହିଁ ନାହିଁ and all the family members have been declared hostile. It is not that outsiders. What are the offenses? 304B is there. 304B, 34 of the ITC and 4 of the DPR. You will also see PW 10 and 11, the brother and mother of the deceased. 10 and 11. They are the best person to at least implicate the petitioner and his parents. 10 is declared hostile by the prosecution. 11 is declared hostile by the prosecution. Well, with the cousin, he is also declared hostile by the prosecution. PW 3, 4, 5, 6, 7, 8, 9, 13, and 14. Hostile.
That is true, my lord. In fact, my lord, the charge sheet submitted against the petitioner showing in the abscond, my lord. Since it put up the height, my lord. And my lord, now when the in-laws, my lord, they face the trial, my lord. They have, my lord, taken to custody, my lord. They have religion bail. They face the trial, my lord. This time being the husband, my lord, he is absconded since height, my lord. Now they are coming here
since 2006, since 2006, there was a stay order by reasonable courts. Unfortunately, during the pendency of the revision case, that is what your lordship has been pleased to take note of. See, the proceeding, you have seen the proceeding. This court proceeding.
What happened?
He tried to explain his presence.
But cognizance taken 2006, my lord. And
2006 se revision.
Issued against him, my lord. By then, it was 6 manner.
Prepare a rate chart and give them. Prepare a rate chart when the cognizance is taken, when he was declared absconding, when the revision petition was filed, when the stay was granted, when it was vacated, he didn't know because the lawyer who was appearing in the revision petition died. 2023 was when he inquired about it, but there was a stay.
Yes, let us understand whether he deliberately did or what. If he was not deliberately did, then what will be the benefit of this equitable judgment for him? We will have to examine that.
2023, my lord. But in fact, my lord, since 2006, my lord, he not cooperated.
2006 to stay actually. 2023 that I have recorded in the last date of hearing. I have recorded that. That means there was a reason pending. So therefore, that is the reason he didn't go.
My lord.
He was obtaining. He was enjoying his stay order. And so, clear chali wale. His wife died subsequently. Let's verify. That is the reason I kept it. And the entry want to continue a week for next week. I thought, okay, and give it then no, not 11th to 21st, 22nd. 11th, 11th, please to apply. 11th, unnecessary at 4 o'clock of reach, there is no point. 21st. 21st. And Mr. Rod, get the, otherwise we will see, we will examine whether any evidence is
I could have very well prayed for a bail taken trial festival, trial purpose which are it will be a futile exercise. Otherwise, I could have humbly prayed for your lordship that my bail taken to just acquittal each one. This one person, this statement. I will they want to have I'll grant you bail here and go and and you appear, you shall be released on bail. And if you think it will suffice for your purpose, I'll say that you appear, you will be released on bail. And the trial will be that will be a futile exercise. I'll demonstrate. Now he is saying citation. I'll give you your lordship citations of Hon'Ble attached for reasonable cause. Where on the ground of acquittal it has been first. Because I have brought it. I'll cite it, my lord, to assist your lordship, man.
Okay, okay. Next.
12.
I don't know. Mediation report has been. I am already agreed. I will not go on your lordship to work. I have said she didn't come, my lord. But mediation date is fixed. Will that stay there already? No, stay. Generally, if matters are sent to mediation, stays on the my permission is that stay may be. No, there is an arrangement. Just see, 11/9/2024, there is an arrangement. You can move application. That arrangement continues. Yes.
Lord, I am agreed by the direction to file an FIR under EP Act, Lord, and last day I have handed over one compilation, Lord. Such direction is completely barred by section 19 of the EP Act, and there are corresponding provisions in the Air Act and Water Act. If my Lord can see that, just to refresh my Lord, the allegation is that I am CEO of the company. That company is not arraigned as a accused, Lord. So that is another aspect. So I had raised 3 issues, Lord. The very cognizance, very initiation of process on the basis of FIR is barred.
Yes.
Then the company is not arraigned as accused. In absence of company being there, I am covered by Anita under principles, Lord. This complaint is not sustainable on the basis of the allegation itself.
Anita under is 138.
No, but that's provisions have been followed in EP Act also, not by this.
Okay.
Then the allegations taken on their face value does not disclose any offense against the company or against me, Lord. And in any case, I joined the company only in 2022. This alleged offense was committed in 2012 or 13. So I made all these submissions, Lord, last day. Other side was there and they were supposed to reply to this, Lord. More so that order, Lord, at page 71. The order, the annexure number 5.
71.
Yeah, it starts from page 70. At page 71, the order of the magistrate.
Yes.
Already there?
Yes.
And this order arises out of petition under 156(3) of the CRPC, filed by complainant, heard
peruse the complaint petition, on perusal of the same, it is found that complainant has set the law into motion with a view to take action against the accused person for commission of offence under section 21, 24 of the Environment Protection Act, under section 21, 31A of the AR Act, and under section 25 and 33 of the Water Act. The complainant has also mentioned the complaint petition that he had given a written report to IIC Badwal PS on so and so, but police refused to receive the same, for which complaint sent written report so and so. IIC Badwal Varsugura for necessary legal action. The complainant has also submitted written report before the Superintendent of Police, Varsugura, but no action has been taken. Yes, I agree. Yes. So, the complete straight of my compilation. There is a specific bar. I have given the copy of the EP Act, Air Act, and Water Act here in my first compilation. There is a specific bar in section 19. Section 19 of the EP Act is page 206 in my compilation, which says, no court shall take cognizance. Yes, I'm there. No court shall take cognizance of offence under this act except upon a complaint made by central government or any authority or officer authorized in this behalf by that government or any person who has given notice of not less than 60 days in manner prescribed of alleged offence for intention to make complaint to the central government or authority or officer authorized or appropriate. And similar provision is made in
Water Act?
Yes, Water Act is made.
Section?
Section 49, page 193 of my compilation.
Yes.
Section 49, exactly same provision. Water Act.
Yes.
And, I need not read this again, exactly same words. Then section 43 of the Air Act also, at page 164 of my compilation was.
Yes.
And they were in the same compilation.
The specific bar is there.
The specific bar
is taken now.
No, not the question of convenience. Last guy explained it. The Act prescribes complete procedure, and I have took judgment of Justice SBC Rao that G1 Rao.
It says expression in use is no court shall take cognizance.
No court shall take cognizance as though you are not there. It's not premature. The rule shall be bad blood. I am saying that there has to be complaint only. It can be FIR. It's not a cognizable offense. So 156 being invoked is not at all permissible in this case, Lord. The only route is, and that was discussed in that G1 Rao case. Yes. The only route is that complaint has to be filed as per the procedure laid down under section 19 of the EP Act.
This is a code unto itself.
Yes. EP Act being in force excludes the corresponding provisions of CRPC, and that is what it was held by Justice Sinha in G1 Rao case. Yes, C Act, so that G1 Rao serial number 4.
Yes.
Serial number 4.
25.
Yes.
Para?
That we come to para number 12.
Yes.
So the act is a special act. It deals with subject mentioned so and so. And the last 3-4 lines of 12, by reason of aforementioned provision, an appropriate authority has specifically authorized intermediate to investigate any complaint or breach of any of the provisions of payroll or for any rules made thereunder and take appropriate action. Then appropriate authority subject to exception provided in payroll, thus is only authorized to investigate cases of breach by any of the provisions thereof, whether penal or otherwise. Ordinarily, this is important. Ordinarily, any person can set criminal law in motion. Parliament and state legislature, however, including the sensitivity and importance of the subject, have carved out a specific areas where violation of any of the provisions of a special statute like payroll can be dealt with only by the authority specified therein. Then we have para 15 again, I'm just skipping. Para 15, providing a special statute, section 4 of the code, which ordinarily would be applicable for investigation into criminal offences or other provisions may not be applicable. Section 4 provides for investigation, inquiry, and trial, etc., according to provisions of the code. Subsection 2 of the code, however, specifically provides that offences under any other law shall be investigated, inquired into, tried, and otherwise dealt with in according to the same provisions.
You show me parameter provision there.
Yes.
Parameter provision to
Yes, mate.
section 4 parameter.
Yes.
So
that is just over para 12, it is quoted.
Yes.
Section 22 of Code, cognizance of offences. No court shall take cognizance of an offence under this except on complaint with the cognizance. Yes. No, my lord, this issue, cognizance is there. Cognizance will not be taken. So this exercise of FIR will itself be futile. And that is what I have remembered the judgment below. And that judgment has followed GO to say that FIR route itself is forbidden. Only route which is permissible is complaint route. In one of the cases which is decided by Bombay High Court,
in 156.3, it's a complaint only. It is route.
156.3,
it is again relegated to the police to,
that relegation is bad. That's what I'm saying. The relegation cannot happen because of this is a complete code, and this says that other method is bad. And that is what Justice S.B. Sinha held in para 20 of this judgment.
That if that is under Toho,
yes, Toho and Toho relying on Toho is relied by the cases by other high courts to rely on EPF also, and so that so para 20
my lord, why is the expression no court shall take cognizance?
I am sorry.
We are not at that stage. It's only 156.3.
I am saying by this route that the states cannot, that this route itself is fertile, and that is what court has said. In some cases, also in EP they are police investigated and filed report. Fortunately, filing report itself is bad because this general CRPC is precluded and only 19 will
see. Tell me where it is precluded. You show that part.
Yes,
not impliedly.
No, expressly, para 20.
Part 20.
Para 20.
Okay.
Para 19.
Express preclude
complete 19 and 20.
Yes.
The number of judgment.
Yes, section
19.
Section 22.
Section 22 of which taking cognizance except on complaint made by appropriate authority or person who made complaint earlier to this laid down in therein, respondent although has all the powers. This is important. Respondents although has all the powers of an investigating agency, it expressly has been statutory report for filing a police report. It can file a complaint petition only as an appropriate authority so as to comply with the requirements contained in F2 essential. If the person, if by reason provisions of payroll, filing a police report is necessary, then forbidden. Then we agree with that. Then we can go to see on their own judgment. See, this is forbidden.
See, 200 rupees you could have taken through a complaint, but not 156.
Yeah, we have gone to the government, 160 days notice.
Yes, yes.
The CA under one judgment is wrong. Because there is another compilation, all the high courts have said that section 19 is mandatory. Bombay High Court, one decided by Justice O also, seeking a division bench. This court
forbidden to find that route. All the 156 route, 200 route you could have taken. That too by a valid complaint by the person who is authorized.
Yes.
That is true.
That's the statutory rule.
In fact, this page the communist had not.
That is what bothering, but it is clarified. Page 19, para 19 and 20. Just see. Cognizance doesn't mean that cognizance of offense. Cognizance of the complaint. That's what it says. Let's see. It is not the cognizance of the offense. It says cognizance of the complaint itself. That is what para 19. Therefore, it says it is forbidden. Police report under 173 is forbidden. How will you explain it? Para 19 and 20. of Jeevan Kumar Rao.
And this Jeevan Kumar has been followed by Punjab High Court in Ravi Shankar Milot. That was
Supreme Court judgment, why should
yes. Then again, Pratap Choli by the Bombay High Court.
My friend will complete today. Another date may given. I will add book and I will cite some distance. Thereafter, pass.
This is the problem you have to address this problem.
I know, man.
Did you follow what he's trying to say is in all the three, Water Act and Air Act and all, these parametric provisions are there. One is sanction. Sanction, we do it for some time. What he says that the very institution of a complaint forwarded in 156.3 is forbidden because it will culminate into 173 report, which is not permissible under law. Had it been a 200, had you had 200 inquiry, you could have followed that way. But this way is not, and the trial court says that 156.3.
That is, I will verify, my lord, that aspect only, my lord, this point, my lord. If not satisfied, then the case will go, but if satisfied, then we did.
You have, then he is directly covered.
My friend already completed, but I
have not completed what, sir. This is the core of the argument.
One point is enough, the other point is main. When will I keep it then?
I have supplied copy to him.
I have given copy. You have given copies? Yes, then you tell me now. Who is argued I have heard? If you overcome that this hurdle, then I may call in to argue on other points.
25th.
25th. If you are not able to satisfy on this point, I will allow the petition. If you are going to satisfy, then I will call upon to address the other points. Okay? That's
what date is giving?
25th.
Yeah.
Sir, I will go to
27, my lord. Subject, my lord.
27.
And don't ask for adjournment.
No.
I have read it.
But also that the complaint in front counsel
we know that he doesn't have a case, so
my friend raised a good point.
Yes. This is a very interesting point.
My lord, in fact, while researching in the courtroom, I found more judgment from this court also, where EPX has been passed on these points.
This is a very direct issue.
Because the intention is that it should not be opening floodgate for all persons to go uncontrolled way.
So everybody filed 153, yes, and police will be involved. These are technical offences. Idea is, see, the whole idea of the act is, this being a technical offence, what police will do? Police will take place or police will take place, police job. It should be sent to police, and how will you investigate, what will investigate? Therefore, it is forbidden. That's the idea of the act. But the magistrate has taken cognizance under this 156.3 and sent it to police for registration of FIR, which is completely barred under the act.
He was in Delhi, he could have filed cases against all white car owners.
Shall I reserve the judgment?
Same partner.
Okay. No problem.
13.
There is an application. The input notice annexed 3, part by the housing systems and an application filed by the opposite party being agreed by the London Administration. And the application section 25 of the DV Act also. The fact of the case is like that. Present opposite party are the wife and minor daughter of the present petitioner 1 is filed an application before the London Administration under section 12 of the DV Act also. And filed an application for expert order also. The London Administration allowed the application and expert. And therefore, after issuance of notice, the present petitioner appeared before the London Administration and filed an application under section 25 of the DV Act for alteration, modification, and clarification. That order passed in expert also. Accordingly, the order has been modified, altered. Having agreed this order, present opposite party, the minor wife and minor daughter filed an application appeal before the London Session Judge also. London Session Judge has modified the final glance for the moment.
That is the next one.
46, also can glance for a moment. Under the application filed by the
initial order was an ex parte order.
Yes, Your Honor. I have filed the application on 25 of the DVR for alteration modification. Accordingly, the negligence
Which were turned down.
Yes, sir.
Which were turned down, then
No, expert. Yeah, there is a provision on an application filed by the aggrieved person. An expert order can be part by the STJ. My expert order in favor of the wife and minor children. Thereafter, after the petition appeared before the line decision, filed an application under section 25 of the DVR for alteration of that order part expert. That order is page 46 hours. 46 hours.
Yes. Yes.
May I read it also? The having heard, that is the second part of the
Yes.
Having heard to the both line council and taking into account the fact that the present petition of the inhabitant of say 2 BSK house situated in Cosmopolis apartments since more than 6 years, along with the respondent number 1, and also considering the apprehension as there is the life of the respondent 2, a widow senior citizen lady. If the petitioner will be allowed to stay, it should be a widow, would be allowed to stay with the respondent number 2 at the residence of 101 Putwa Enclave apartment, Bhubaneswar. The order passed in the purchase charge that price is modified to the extent that the petitioner along with her minor child will stay in the flat number 141, Block A, Cosmopolis apartment, Dunduma, Khandiri, Bhubaneswar, Your Lordship. What happened?
Or any other house?
Yes.
Yeah. If the convenience of
If I communicate the petition, the land along with the electric bill and applicable paid by the me. Accordingly, what as per the direction passed by the land agency, I myself accommodated in flat. That is the Krishnapriya apartment, flat number 208. And all Stridhana properties are in that house, Your Lordship, for accommodation of my wife and my minor child, Your Lordship. The taking rent. Yes.
Yes.
According to the electric bill, water bill, other but accordingly, by the order of the session judge, I have handed over the key of that apartment to my wife, Your Lordship. Accordingly, he received that, but that house didn't stay there in that house, Your Lordship, along the minor child. But filed an appeal, did the say that our wife and minor child before appeal session judge come to the appeal order. Yes, Your Lordship. That is page relevant page is 754, Your Lordship. I'm not wasting your time, Your Lordship. In the premises, 1054, Your Lordship.
Yes.
In the premises, taking into consideration the above fact and submission, the input narrated 4.22 is modified to the extent that is the modified that against the house and unity during water, the responsible pay is 20,000 Your Yes. I was accommodated in apartment 208 in the Krishnapriya apartment, flat apartment, and I bear all the expenses in towards over in that 20,000 rupees you will pay. That's what the order. Yes. That order being agreed to say there,
you are challenging that.
Yes, Your Honor.
Yes. What are the grounds?
On the grounds, already I have accommodated flat in this is a need for the wife and minor child.
Now she survive.
I will put the maintenance, sir. How? What is the 10,000? 10,000?
Separately.
Yes, sir.
10,000 to both of them.
Expect the order. Yes, expect the order.
Yes. Now this order says that 20,000 over and above everything you have to pay 20,000.
Yes, that part is agreed by that. No, sir.
You say that this is excessive.
Excessive. I have already accommodated on flat also, and the paying the rent what the outside flat. And electric bill, water bill, other etc. And all right.
Yes, but paying is something different, and survival for other expenses also you have to pay 10,000 rupees you are paying already.
Yes,
whether it is educated or not, that is tuition. That's all.
That's right. So, my respect already I have accommodated on flat and all Stridhana from.
Don't repeat all these things.
I understood. That is my whole challenge.
You don't make it a constitutional issue. You have to pay. Whether 20,000 rupees is excessive or not, that's the only question.
I must to that my respect
now, as a result of this order and the maintenance order, you have to pay 30,000 rupees and accommodation. Accommodation you have already given to her.
Yes.
And 30,000 rupees is the excessive amount, how much it has to be reduced, that is an appellate court. Yes, sir. 1 minute, I understood. Yes.
Madam, as far as this petitioner is concerned, I'm not getting into the facts of the case.
Yes.
Just pinpointing the submission what he made. First thing, after that I will be coming to the legal points. First thing, as far as payment of 10,000 rupees is concerned, he has never paid. And it was after the execution order, he has paid something. And till 6 months, he has not paid. Okay, number one. Number two, he is yet to comply. The order of this Hon'Ble Court passed and dated on
The first order.
first order and the second order.
Yes.
Interestingly, in the second order, in the dated that is 25th 2024. This Hon'Ble Court has directed that be that as me, the petitioner number one is directed to verify from the school regarding dues towards the tuition fees of his daughter. If any tuition fee is due, the same shall be made good by the petitioner number one by the state. Very cunningly, what he did, he paid the first quarter of the payment. First quarter till up to June.
Okay.
Then he has not paid a single file, not even for the braces, not even for the other expenses for the school, nothing for which the child is left out. पूरा एक गोटे साहब बस में बोला 1 year is gone.
Number one child है.
To that context, or
There is an order of this court.
my lordship,
No, don't make it a big issue. No, are you paying or not?
I am ready.
He is making easy. I'll tell you. I requested him to assist the court.
Yes,
he will not make a wrong statement because he is not defending someone. He is arguing for
Documents. I have kind of that I have planned.
What are you doing?
And being a professor and advocate also, the present petition also, but second, I have already cleared this tuition fee with my audio also. Any letter is whether issued by the school towards outstanding show me lordship, I am ready to deposit lordship. Rather, the president of the party did not send my word to the school lordship. School of the communication lines, these are the outstanding lordship.
Why are you making school a party? You should have gone and asked somebody saying that I have not told you tuition fees also. And you are saying that I have not communicated. I have not. What is this?
I have already cleared your lordship. I have got
everything you have paid in October. And in school, you know, in a private school?
Yes, sir.
In June, you know to pay. If what you keep on asking you and
that was only tuition fee.
you should have paid. Some communication from the school to you through him.
I am not saying any communication also.
There is no end to this kind of fighting. You know, you have to either settle or pay. As simple as that.
This is a
सर मु किछि कहबाक चाहूची
आपण एडवोकेट सुन रहंतु
मोर सर एडवोकेट नाहंती मोर एडवोकेट आसी नाहंती अभी
आपण
मु ए केस रे गोटे पार्टी हेबाक चाहूची सर
आपण के
मु संध्या रानीपाल वाइफ ऑफ सुशांत कुमार त्रिपाठी मो हस्बैंड भुवनेश्वर बार एसोसिएशन कोर्ट रे एडवोकेट अछंती सर
आपण ए केस रे कोन आपण
मु सर ए केस रे काजल त्रिपाठी को गोटे केस रे पार्टी हेबाक चाहूची जेहेतु मो हस्बैंड को काजल त्रिपाठी मैरिज करके रहउचंती 6 मास हेलानी 6 मास 6 दिन
मैडम सेही जोड़ा आ भीतर किछि होय मेंटेनेंस आपण
केस सारी मत फाइल कर डिवोर्स केस फाइल कर भुवनेश्वर कोर्ट रे मोर मेंटेनेंस केस फाइल होइछि सर
आपण को सेही केस रे आपण हस्बैंड से तो जो केस चली थी ओही केस रे आपण नेसेसरी पार्टी नांती
ये सर मैरिज को
एटा मेंटेनेंस ताको मेंटेनेंस का हस्बैंड से तो आपण आसे तो की संपर्क नहीं
मो सर किछि कहयो
गेटिंग वेरी कॉम्प्लिकेटेड clear all the dues of the school and come Monday.
Monday will also have outstanding date
then you don't want to pay then. That's the whole problem.
I've got 7-8 days after you to put your
no problem. You keep on fighting, but the child's school fees has to be paid. Come what may. To pay it, I'll put it on, what is it? What is it? No, you have to, because there is already there is a mail from the school. Already there is a mail from the school.
सर मो हस्बैंड को लुचेई के रख
No, ଆପଣ ଏଠି ଏଇ ମେଟରେ ଆପଣ କିଛି କହିବାର ନାହିଁ, ଆପଣ ଅନ୍ୟ ଜିନିଷ କରନ୍ତୁ। ଆପଣ କିଏ କହିଲେ ଏଠି ଆଜି କେସ୍ ଲାଗିଛନ୍ତି?
केस रे मोर एडवोकेट जे थिले तांको देह खराब हे जाईची मु 25-50 केस रे
ନାଇଁ ଆପଣଙ୍କୁ ଏଇ କେସ୍ ଟା ଆଜି ଡେଟ୍ ଅଛି ବୋଲି କିଏ କହିଲେ ଆପଣଙ୍କୁ?
मते भुवनेश्वर कोर्ट रे मोर एडवोकेट कहले से सब केस रे तांकर जो माने बुझुचंती तांको हस्बैंड कर जे केस नै चंती से एडवोकेट मो एडवोकेट से मन सब कथा है मते जणैले तांकर केस अछि
ଜଣେଇଲେ ଯାଇ କହିଲେ କୋର୍ଟ ରେ କୁହ ବୋଲି
आ फाइल करथली आरथरिक जे 25-50 रे फाइल कर एप्लीकेशन करथली जे मोर थरे रही
ଆପଣ ଏଇ କେସ୍ ରେ କିଛି ଆପ୍ଲିକେସନ ଏଣ୍ଟିଟି ନେଇ ପାରିବନି, ଆପଣ ଅନ୍ୟ ଜିନିଷ କରନ୍ତୁ, ଆପଣ ଯାହା କରିବେ ଏଇ କେସ୍ ରେ ଆପଣ କିଛି ଲେନା ଦେନା ନାହିଁ, ଭିତରେ ମେଣ୍ଟେନ ଯାହା ଅଛି
ଆଜ୍ଞା
ଆପଣ ସେଇଠି କରନ୍ତୁ ଯାହା କରିବେ ଆପଣ କରନ୍ତୁ, କିଛି ଅସୁବିଧା ନାହିଁ,
ଆଜ୍ଞା
ଆପଣ ଯାହା ଗ୍ରିଭେନ୍ସ ଅଛି
ଆଜ୍ଞା
ସର୍ଟ इट वेटिंग चेक ठीक है ओके यस चल
That's 14 and 15.
ऑर्गेनाइज्ड 14 and 15
Frame order.
I'm not taking it from school. I'm not taking it up.
Sir, wait a second.
Will it be there? I have not done that, but prepare a proceeding. Let it be in the board itself.
116, 116.
Yes.
There are three matters to be heard together. Two matters are on the board. 2871 of 24 is not there.
2871. That's
CRL 3, 2871 of 24.
24.
Interim order to continue in all.
Interim order to continue and list that matter also.
119 your lordship was fixed to 3 o'clock minutes. However, it has not been.
Yesterday only I received the paper.
That's what I'm saying.
Let it be listed in November, the last November.
That's what that is. My submit. I understand. I am. That is not one question.
His lordship is 1989, 99, 2001.
Today 92, 96 I have done.
My submit.
Kindly allow me. What is it?
I'm just briefing the lordship. I have specifically made out a case on the admission stage that there is absolutely no case made out. So that's why lordship it has fallen from your lordship. I have not mentioned that it is a case of acquittal. That is why it is to be posted for hearing. And my lords, here there is no demand. Demand has not been proved. Recovery is not from me. And my lords, the person from whom recovery was made, he has not been made and witness convicted. Still, I have been convicted. That is why the lordship has specifically fixed it to 3. And directly, but he, what my learned senior submit that because of some other matters were not taken, my rights cannot be placed. And only that is okay. I am not to get
24, 25th, anything?
Yes, November last week.
24th time.
Well, what is the difficulty is, my 6 months service is there because the lordship knows the lordship has expressed in that other day also. I have been dismissed, my lords. Even though I have no connected to the, so I have been
service. I won't do it.
Second week of November.
The areas can be claimed and get from the government.
Whatever the trauma I am suffering.
After winning this case.
Okay, now wrong or right, whatever, there is a conviction order.
Yes, well, type on ballot.
First appeal, that's what
119.
Same. There are two matters. First, to my learned senior. Second, I am.
Paperwork is not prepared. You have to.
Paperwork is prepared, Manoj, so it is there. I directed me to prepare the paperwork. I have prepared it. It is there. I will give it to you. And it is there to the officer. Yes, yes. It is.
So let it
get ready and come with. I am ready to do also, madam. Come with a note so that we will finish it up. 10 to 12.
Specific direction was there.
November.
27 November. Without money, no further adjournment will be.
I'm sorry. Paging. So I will cite it before your lordship while you are being. And 120 may be taken up in December. That is not a single scrap of paper is
who is appearing? Mr. Gupta.
It is of the year 2024. Nobody is there.
Oh, let it go to weekly.
Lordship 117 and 18.
117?
117 and 118, Lordship, that vigilance case, Lordship. That is specifically urgent to, in labor code, that is urgent to 12th, Lordship.
12th of who?
12th of November.
12th November.
Yes, Lordship.
Oh, well, this will remain in the board. It will come tomorrow and thereafter also. Repeating it.
11th.
Okay, 11.
11.
Public.
Yes,